A very good afternoon to our eminent guests, council chair, co-chair, invited session chair, eminent national international speakers, all the participants, ladies and gentlemen. A very warm welcome to all of you to the ASSOCHAM first international conference on whistleblower policy, which is being conducted by ASSOCHAM National Council for Legal Affairs Regulatory Reforms and ASSOCHAM National Council for Corporate Affairs, Company Law and Corporate Governance. The conference is being sponsored, supported by Renew Power, SpiceJet Transport Corporation of India Limited, Smart Bharat Group, BSE Investor Protection Fund, and Reliance Industries Limited. Ladies and gentlemen, in India, the Whistleblower Protection Act 2014 was enacted to provide a framework to investigate alleged corruption and misuse of power by public servants and to protect persons who allege for wrongdoings. The enactment of the act was a result of painstaking efforts and sacrifice of the whistleblowers. Some of them had lost their lives due to their act of whistleblowing, but for their act was common goodness of all of us. Now, there is well-established system in place where CBC inter alia also publishes the yearly report cases in government and public institutions. The older version of the act says that a whistleblower in India cannot make anonymous complaints under the act, but after a resolution brought to the public interest disclosure and protection of informer, the complaints are allowed to be received under the category of PIDP through registered or speed, and the officers cannot insist on to disclose the identity of informer. In this regard, CBC noted in year 2021, there are the gaps in implementation and officers need to be more trained on in this regard. There are public critics and views about the percentage of investigation in the cases, lengthy procedures, and the conviction rate. And the data studies are really mind-boggling in context of findings from such reports as well. The scenario in private corporate sector is different, as the Companies Act 2013 and the SEBI, through revision of clause 49 of the listing agreement, have made it mandatory for certain classes of companies to put in place a whistleblower policy. Hence, the need of ours to look at the effectiveness of policies together with impact outcomes in India so far. So there is a lot more to take away from this initiative, and perhaps this ASSOCHAM conference is first ever in terms of format, topics, content, and inclusion of diverse of a range of national, international acclaimed speakers on the subject, being expert in this conference. Let me take the opportunity to briefly introduce to all the eminent guests and speakers of the inaugural session. As we go, we have our special guest, Ms. Yatri Dave. She is Chief Vigilance Officer, Securities Exchange Board of India. We have with us Mr. Neeraj Kulshrestha, Chief Regulatory Officer, Bombay Stock Exchange Limited. CA Dr. Ashok Haldia, Chairman Board of Triple IPO of ICAI and Chairman ASSOCHAM Task Force for Accounting Standards, Sustainability Accounting and Integrated Financial Reporting. We have Mr. Hemant Sahai, Chairman ASSOCHAM National Council for Legal Affairs and Regulatory Reforms and founding partner HSA Advocates. We have Mr. Vijay Sachdev, Co-Chairman ASSOCHAM National Council for Corporate Affairs, Company Law and Corporate Governance. And we have learned audience, including legal professionals, general counsels, media representatives, academicians, researchers, and delegates from various sectors. At the outset, let me invite Mr. Vijay Sachdev, Co-Chairman ASSOCHAM National Council for Corporate Affairs, Company Law and Corporate Governance, for your welcome address. I would like to mention here that our council chairperson, Ms. Preeti Malhotra, had some urgent appointment and she had to excuse for. So in that case, I would request Mr. Vijay Sachdev to please come and give your welcome address. Over to you, Mr. Vijay Sachdev. Sir, you are muted. Yeah.
Yeah, our chairperson, Ms. Preeti Malhotra, was to join this event, but she got tied up. So continuing here further, at the outset, let me welcome all the dignitaries over this inaugural session here. At the outset, let me welcome Ms. Yatri Dave Vitekar, the Chief Vigilance Officer from Security Exchange Board of India. Mr. Neeraj Kulshrestha, the Chief Regulatory Officer of Bombay Stock Exchange. Our mentor and senior member, CA Dr. Ashok Haldia, and my colleague, Mr. Hemant Sahai, who chairs the Legal Affairs and Regulatory Reforms Committee. A very warm welcome to all the dignitaries who have joined us today at ASSOCHAM International Virtual Conference on Whistleblower Policy. The theme for today's conference is on a quite important and sensitive topic, and equally or rather more important for overall corporate governance. Having said that, the subject is also the need of the hour to address, and it is beyond legislative framework that pertains to the letter and spirit of whistleblowing, which is often seen as a center of criticism. We have to recollect that in India, the safety and protection theme got discussed in 2001, and there was a very big and very sad event which happened in 2003, where one NHI engineer, Mr. Satyendra Dubey, he had blown the whistle, and he wrote to the Prime Minister office about uh, certain wrongdoings which he observed in the government contracts, offices, and at political level. And then he was murdered upon. So that created a lot of sensation in the Indian diaspora. And of course, whistleblower has been very vital and important as seen at the global level also. So India also later became a signatory to the UN Convention which against corruption in 2005. So raising the bar, India also worked upon that. And finally, a whistleblower protection bill which came in 2011. So I'm sure that we have our legal fraternity members and various academicians who will throw more light about the history and involvement of on whistleblower. But let me highlight here for our event today that I see that there are the five pillars or five uh, important aspects on whistleblower, which I think as ASSOCHAM we would like to address in the event today. So these five pillars, I would say, is one is on the legal side, which I'll not speak much, but the framework, the evolvement, the evolvement which happened since 2001 in Indian context and globally since much before. Second is on the framework. When we look at public or private enterprises, it is very important that whistleblower has a very streamlined and methodically prepared framework. Because if I am an employee of a public company working at a remote plant or working on a remote infrastructure site, or I am an employee of a corporate house and working at some remote location or some department or even at head office right in the ambit of all the CXOs. If I observe a wrongdoing, that framework should enable me to give a sense of responsibility, because all what we are doing, the whistleblower has to do is to raise the blow in larger interest of the company. It is not part of his role, it is not part of his immediate responsibility. But while in legal sense, employee has to take care of company's assets and reputation. However, at the same time, that is where the whistleblower has to go out of the box. So he should get the proper communication that how he has to raise the whistle. Similarly, he should feel protected because he might be blowing a whistle for his boss, for a CXO, or for a very leading or influential or a old employee in the organization. So that framework is very important. And as I said, along with that, the awareness, the protection of whistleblower, and finally the culture, because the organization may be private or public, has to give confidence to employees that if a whistle has been blown and it has been investigated and found on merits, then there should be right actions which are being taken to create motivations and success stories going forward. So with this, I will not take much time, but around the practical aspects of whistleblower, highlighting the protection and giving a sense of responsibility to the whistleblower is what we would be seeing as theme of the event during the next couple of hours through the event. We have two panels. One is headed by our dear Dr. Ashok Kaldia, and having various leading speakers on that. And second is headed by our dear friend and senior member from the fraternity, Advocate GP Madan. I'm sure all of you will enjoy the event and find it very useful. With that, back to you, Santosh, and thank you once again to all the members on the forum here and all our guests today. Thank you.
Thank you very much, Vijay Sachdev sir, for your welcome address. Uh, I do notice and acknowledge the presence of Mr. Vincent McKnight, who had joined at a very early hour from US. We welcome you, Mr. Vincent, and we have been also joined by Dr. Terrain Vian. Thank you very much for joining us. And without taking much time, I would request and invite our council chairman, Mr. Hemant Sahai, who is the chairman of ASSOCHAM National Council for Legal Affairs and Regulatory Reforms and managing partner with HSA Legal. So I invite over to you, Mr. Sahai, for your opening comments, opening remarks.
Thank you very much, Santosh. Good afternoon, good morning, welcome to everyone. I don't want to repeat a lot of the content that is going to be discussed and what Vijay very succinctly kind of set out in the framework. While India has legislative framework, but we find, and I think that's going to be one of the themes, that perhaps the legislative framework is inadequate. And it requires very strong, robust policy support, and I'm talking at the corporate level. So corporate level policy support. So while, of course, SEBI and of course under the Companies Act, there are some robust provisions, but I think the culture which I alluded to needs to be strengthened. I think some of the bigger issues are about anonymity, lack of neutrality, and of course, the protection available to the whistleblower. Some of the statistics are startling, and in fact, they're scary. So one study actually suggests that over 90% of the whistleblowers were somehow victimized, and the victimization can be, in very subtle forms also. In today's day and age, it's not just a question of a direct attack, which is unfortunate, attacks, physical attacks, but also subtle attacks which can impact the career, the future of the whistleblower. So my submission to this August House would be that in the discussions, perhaps certain international experiences, which by the way do exist in countries like the USA and UK and Australia, how can India imbibe and absorb some of those examples and precedents to strengthen the protection available to a whistleblower? How do we actually make the whole anonymity issue more institutionalized? I understand it's a double-edged sword, but I think we need to learn from international experience. Should there be an incentivization to allow people to come forth and actually, blow the whistle, so to say? And if there is a good faith disclosure and can be shown and demonstrated that it was actually good faith, should he be penalized, a whistleblower be penalized in case some of his allegations are found to be unfounded? And I think it's important to delve on that a little bit, because many a times the whistleblower doesn't necessarily have all the evidence available to him, but enough to make a certain allegation. And should he be penalized for being a good Samaritan or being a person who's got the interests of the organization, both public and corporate, at heart? And eventually, I think the purpose of forums like this and discussions like this is to make recommendations, both legislative changes or policy changes that can be brought about to strengthen the framework. There's no doubt, in conclusion, there is no doubt that the whole whistleblowing protocols and the framework affect each one of us in some form or the other, not just those people in the corporate world. So the example that was given of the engineer in NHAI, technically that is really a public issue, and therefore it does affect each one of us in some form or the other. We should not just turn a blind eye and just say that it doesn't bother me, it doesn't affect me. It does, because public funds are at stake, whether in a corporate sector or even in a PSU kind of a framework, or even other organizations. With that, let me hand the baton back to Santosh to take the proceedings further. Thank you very much.
Thank you very much, Mr. Sahai, for your opening address. Now, let me take the opportunity of inviting CA Dr. Ashok Haldia, Chairman Board of IIIP of ICAI and Chairman ASSOCHAM Task Force for Accounting Standards, Sustainability Accounting, Integrated Financial Reporting. I'm sure that Sir has been for so long the Secretary to the Institute of Chartered Accountants of India. He understands the intricacies, implications, and he can better guide to the corporate on this particular subject, which pertains to the job role of the chartered accountants. Because whenever the whistle is blown, the role of the CA and professional company secretaries, like people that comes on to their part to respond to their such kind of the whistleblowing activism of the people. So over to you, Haldia. Look forward to learning from you on subject, and handing over the mic to you, sir.
Thank you, Santoshji. And to begin with, distinguished the guests for this inaugural session, Ms. Dave, Chief Vigilance Officer, SEBI, Mr. Kulshrestha, the CRO of BSE, and also Mr. Hemant Shah and Mr. Vijay Sachdeva. Indeed, a great pleasure to be here in the inaugural session. And let me first compliment the committee for reasoning out need for a seminar, discussion, deliberation, discourse on this vital topic of whistleblower policy. The whistleblower policy is nothing new in the context of the public governance or the corporate sector governance. We have seen since ages, other centuries, from the times of Chanakya, there is a whistleblowing system in one or other manner in place. And we have seen in the corporate sector context, the regulators intervening and encouraging the whistleblower mechanism, right from beginning from the US, the Sarbanes-Oxley Act, and then the law in the UK, and then the law in India, and more importantly, the LODR requirement. They focus enough light, enough guidance on the letter and spirit of the whistleblowing policy. While the latter is important, and that has been very well laid out by the SEBI and also the overarching provisions under the Companies Act, what is important to me and what Mr. Hemant Shah has pointed out is the spirit, is the culture, is the mindset of everyone who is one or other way is responsible for evolving the policy system and the processes, and more importantly, seeing that those who make whistleblowing complaints are protected. In fact, it's also what whistleblowing policy says and what the spirit says, that the whistle should be blown for the meaningful purposes. And it is blown to a public authority for the public purpose. Now, that's something which is a possible guidance for the whistleblower. Now, whistleblower, as Mr. Shah and Mr. Sachdeva said, may not be in possession of enough document and evidence. He can only give the lead. Now, how that till that lead is supported by the evidence, how that process is handled, because that becomes very sensitive, is very important. At the same time, how that evidence are to be collected, by whom and in what manner, that also becomes very important. Now, once having collected and having found something substantive into that, then the issue comes of the action, the implementation, and also the protection of the whistleblower. I think the last part and the first part that I said is very important, that the whistle is blown for meaningful purposes, and lastly, once it is blown by someone, he can be internal, he can be external. Internal can be employees, maybe the stakeholders, the government, the regulators, anybody can be the whistleblower. But the point is that particularly when it comes to the employees, and as Mr. Sachdeva pointed out, the case of an employee, 2003, well-known case. Now, how do we protect them? While it is said, it is stated in the policies, in the law, that there should be enough provision and mechanisms for the protection. But does that protection really takes place? Mr. Hemant Shah talks about the international experience. And I remember having read a research report about a year or 18 months before, coming out of the UK, where it said that the protection is more on the record rather than in the spirit. And they tracked a large number of whistleblowers as to what happens to them after they have blown the whistle. And unfortunately, in most of the cases, they were harassed, in one or other manner. Now that harassment, I am not saying it's an extreme harassment, but then within the letter of the law, the harassment takes place of an employee. The law might require that you cannot dispense with these services, terminate the services of the whistleblower, but there are many other ways in the hands of the management to deal with that whistleblower. Now, that is one thing. How do we take care of that? The second thing is, how many of them finally lose the job, or they are made to leave the job? The law requires, the law gives the protection for the employment to the whistleblower. The issue is, how do we, he might be forced to leave the, and this has happened in a large number of cases. And thirdly, once you have blown the whistles, then the entire world considers you untouchable. You can't seek employment anywhere, and if you seek an employment, and if that tax goes with you, you're not likely to get employment anywhere. Now, these are the practical realities, and I believe it's a challenge for everybody: government, the corporates, the Trade and Industry Association, in the interest of ensuring good governance, and also of the regulators. I know it is easier said than done, but then that's the challenge that one has to. And it is also very important that we encourage, we motivate the meaningful, whistleblowing, and we are able to address disgrace, demotivate, without creating frightfulness in the minds of the stakeholders for making the whistleblowing. So that's also requires a cultural change, maybe somewhere where the regulators find that it's not based on any substance, and it was just on hearsay basis, without giving any lead to evidences, or without ultimately leading to any evidences. Possibly, in one or other manner, these kinds of things have to be dealt with appropriately by the regulators or by the government. So that's I thought, from that perspective, this webinar becomes very important. I must again compliment the committee for doing this, and indeed that we have two persons of, you have the stakeholders, all the relevant stakeholders present in the meeting, the regulators, the professionals, the corporates, and also the international participations for this purpose. And I'm sure a large number of requests would come out. And I would suggest, Santoshji and Sachdevaji, that the recommendations coming out of this webinar should go in preparing a paper by the ASSOCHAM for submission to the regulators and also to the corporates. Maybe you bring out a best practice guide for the corporates as to how to deal with the whistleblowers or the whistleblowing. There is a mechanism now for the corporates. It becomes necessary. They keep on receiving the number of complaints, some anonymous, some non-anonymous. An anonymous complaint might have substance. Non-anonymous complaints may not have substance. Now the issue is that the corporate need to look into, do they add value to the organization, even if it is anonymous? Does it add value to the corporate governance, to the corporate growth, the corporate performance? If yes, then it is something to be looked into. Maybe law may or may not require to be looked into, but then it is something to be looked into. If it is non-anonymous, it is frivolous. Possibly they also need it to a logical conclusion in terms of saying that it is a frivolous complaint. So I would say this webinar is very well laid out and possibly a good thing for the ASSOCHAM to take that further forward. With that, Santoshji and ladies and gentlemen, thank you very much. I look forward to interact with all of you during the first session. Thank you very much.
Thank you very much, Dr. Ashok Ajay. Now moving forward, ladies and gentlemen, to share the perspectives of stock exchange, we have eminent guest, Mr. Neeraj Kulshrestha. He is Chief Regulatory Officer with Bombay Stock Exchange Limited. Let us learn from him that how listed companies align and report to BSE about whistleblower cases. How does BSE practice its policy in case of complaints under protected disclosure? And if it receives any anonymous complaints, what does it do? What is his message to investors from India and overseas who are attending this conference? Now I invite Mr. Neeraj Kulshrestha, sir, to learn from you, and over to you. The mic is to you, sir.
Thank you, Santoshji. Uh, uh, Good afternoon, everyone. First of all, let me thank ASSOCHAM for organizing this event, which is very relevant because it's not really talking only about the whistleblower policy, but also in terms of letter and spirit and its effectiveness. So this is the first. I also would like to, this particular event, when I see it's very topical, and broadly it reflects a very important point, which is governance. Now, from a governance point of view, and we will purely talk about this particular aspect because governance in today's time may have multiple meanings, but from a very elementary perspective, we see today is a time when social media is very active. There are ways and means where so you don't really need a newspaper for news. A lot of news would be just available on websites, or would be floating around in WhatsApp, or various other social media forums. Given this kind of a percept, and the other piece, primarily because we come from the world which is essentially of listed companies, there is a lot of shareholder activism which is happening, particularly because institutional shareholders, etc., and plus even several retail shareholders or employees also keep. I mean, there are continuous complaints which keep coming. As stock exchanges, we are the recipients of a lot of these complaints, etc., and where then we have to ask the companies to act, and the companies, of course, are obligated to report such things. Broadly, this again translates into a very basic aspect. What is a stock exchange for? Stock exchange, while it provides a platform where stocks get traded, but we are in a broader sense, we are also an entity which is in the business of trust. The shareholders trust, the stakeholders trust, etc., because the price, whatever is reflected on the stock exchange with respect to a company, essentially reflects the trust. And therefore, to ensure adequate trustworthiness, and there are, I see that Madam Chief Vigilance Officer of SEBI is already here, also attending this. So if we see the three broad pillars which have enunciated this whole principle of whistleblower, there is SEBI, there is Companies Act, and then there is the Whistleblower Act. So with these three pillars, there is a proper framework. We are not really talking of adequacy, inadequacy. Of course, at the end, there is a reasonably good framework. So companies which are ethical certainly have a framework. And if people genuinely want to work on such a framework, it helps. So I will not go into the specifics of how the process happens, etc. But broadly, given that there are realities which are taking place, there are wrongdoings which are taking corruption, wrongdoing, or even if it's a simple feedback mechanism, whistleblower, the policy encourages that. Now, when we talk of effectiveness, the effectiveness aspect, so today, as of today, listed companies are bound by this Whistleblower Act. They are bound by following all the principles related to this. But how do you ensure effectiveness? And since that is the topic today, I will talk about one of the most important aspects of that would be the anonymity. So as long as we encourage anonymous complaints, now anonymous complaints, has various paradigms. I do understand that, because whether an anonymous complaint should be taken or not taken, etc., etc. Any company which is following good governance would certainly take into account even an anonymous complaint, to the extent that it has to be verified, and only after that you give it up. So you want to eliminate it, do it, but then please do verify, because understand that these are at the end of it, these policies are such these kind of complaints are such which are in the interest of the company in the larger sense. It protects the company. It tries to prevent wrongdoing. If if these are genuine complaints, etc. So that's where there is a positivity about such kind of actions. And the second is with respect to the protection aspect, which has already been talked about. So I will not refer to that as well. But I will refer to the other aspect that, we must also understand that for the stakeholders who are associated with, and since we are talking in the sense of corporates, this is also a duty. So every stakeholder of the company has a duty. Every employee of a company has a duty as well, because the employee, he or she has to have the interest of the company supreme. So when we look at the duty aspect from an employee perspective, the aspects which come out are that, as if we are a good organization and if we have an effective policy, it should clearly, we need to ensure that all employees are aware of the policy, number one. Number two, they should be aware of the what and the how. In the sense, what should be done if I have a concern, and how do I do it? So these are important aspects. That is how we measure effectiveness. Second is, does the company take timely action? So there is a process to be followed. Whether timely action is taken or not, that's the second important piece from my perspective. And this is based on my analysis of some of the data. The third is with respect to, are we regularly, so anyone who's a complainant, or if there is an identity known, is there some way we are updating the person? Because so a typical way that good companies we have observed is that in case a complaint comes, they do go back to that same email ID and seek for more information to ensure that, so general complaints, I mean, you can't really act. So therefore, but at least actions, some action, if it is seen, then it appears that, okay, the company is doing some work about it. The other aspect is that, which is, I think, probably important, I'm mentioning it later, is this is typically clearly a board, audit committee, and senior management driven policy. So if there is importance given at that level, automatically it would certainly be effective and a strong policy. And lastly, of course, the action associated with it. Now, when we, with these, I mean, so these elements, if they are present, I would call it a reasonably effective policy. Along with that, so what does the data tell us when we look at corporates? So broadly, based on experience and discussion with corporates, and also, of course, the reportings that have been done, when we analyze that, a few elements come out. One is that there is a positive angle to it, because it has thrown out several aspects which should have been acted upon. And because of the lack of that in a timely manner, some of these issues have come out. Yes, it may have led to other aspects which, people were talking about harassment, etc. Mr. Haldi was mentioning about harassment, etc., etc. But those aspects, of course, will not really be reflected so openly to us as a stock exchange, because we are just recipient of information, but based on the feedback. And the positive aspects are also there, because, in the sense, markets do reward companies where there is a positivity in terms of such kind of actions being taken or reporting of such actions. On the other side, we do understand that, there are other angles to it. For example, there have been cases of people trying to report investors, or investors or probably employees reporting whistleblower complaints, but then it's essentially their own disputes in terms of salary, etc., trying to be brought through this route, etc., etc., which again reflects some aspects of it, but may not be totally, in the sense of, these are more individual disputes rather than, in the nature of some serious wrongdoing, maybe that. One interesting aspect that we have seen, and which we have, also come across, has been that some of the corporates try to, some of the organizations or individuals, we can say, try to file defamation cases against such whistleblowers. So they require identity of such persons, etc., etc. So those are cases. There are aspects of that as well which are there. And whenever we are asked about such things, we are very clear that you cannot disclose the identity of the complainant. You cannot disclose the details. Yes, while you can share the complaints, but you have to mask any identity, etc., so that the anonymity is maintained. So, as I said, in a wholesome, if we see, this is clearly a governance aspect, which is very important from a corporate perspective. The second is that it is, as I said, effectiveness. There are ways to measure it, and any company which is genuinely interested can certainly measure based on some of the points that I mentioned, and I'm sure there are much more to that. And finally, while the results may be mixed, in the overall sense, this is a positive for the companies, and all companies. Any complaint that comes, they have to at least review, assess, and all this should be totally driven from the senior management and the board, etc. So I'll stop here. Thank you very much. It was a pleasure speaking here.
Thank you very much, Neeraj Kulshrestha sir, for your lightning address and for sharing perspectives of Bombay Stock Exchange. Now, moving forward, ladies and gentlemen, as we know that the listed entities have very nicely published the whistleblower policy on portals of their respective organizations, which clearly indicates the policies are impressive in letter and spirit. But having said so, if we look at the level of education about policy itself amongst the internal and external stakeholders, I think the effectiveness seems to be at a very low, and hence its consequential impact and effect relationship could be different in context of corporate governance as a whole. In June last year, SEBI increased the reward payable to whistleblowers under its provision of insider trading regulation to rupees 10 crore from 1 crore as earlier mark, to further encouraging whistleblowers to come forward to the regulator. If we look at with SEBI, it is unlike the case of whistleblower mechanism under Central Vigilance Commission as the one who seeks to win under SEBI's mechanism, he or she has to disclose the identity, and hence the fellow has to take all precautionary and safety measures against risk which may be associated with threat of retaliation, mental trauma, inability to prove claims, loss of jobs, there are the instances where one has to be prepared before filing a complaint as a disclosed identity that he or she may not be able to do further jobs in career. So I think regulators' perspectives are very important, and to enlighten us on the perspectives of SEBI, we have a special guest, Ms. Yatri Dave. She is Chief Vigilance Officer of Securities and Exchange Board of India. Just a bit profile about her self. I would like to mention, read her profile. She is the civil servant belonging to the Indian Railway Personal Services 2001 batch. She is currently posted as CVO with SEBI. Prior to this assignment, she has served as Chairman Railway Recruitment Board RRB in Mumbai and various other posts in Indian Railways like Chief Personnel Officer, Western Railways. She has served as freelance journalist with Times of India, Express Group. She holds a master degree from University of Mumbai in international politics, and she has done the advanced management program in public policy from the Indian School of Business and is a graduate in political science from the University of Mumbai. So without taking much time, I request and invite our special guest for the day, Madam Yatri Dave, to please enlighten us on the subject, which of course with SEBI, you are the one who is leading, and the stakeholders look up to you. That how the good governance flows from top to the bottom of the corporates, and then stakeholders get benefited out of it. So over to you, Madam Yatri Dave. We welcome you.
A very good afternoon to all the ladies and gentlemen. Thank you, ASSOCHAM, for inviting me. This is a very, very topical subject today that we have taken up, which is whistleblowers. I want to talk about, since we have discussed so much about the policy of whistleblowers, I would like to bring to the forum the practitioner's perspective of whistleblower. So to give a perspective to it, on an average day, we get close to 30,000 complaints, and it is massive. My own email ID, I have 2 of them, and it's always flooded. So through this forum, since we are discussing the policy, I would like to say that there are three kinds of complaints which are actually in some ways blunting the effectiveness of this policy. Now, one of the first things is that when a whistleblower chooses to make a complaint as an anonymous person, there are various reasons, and all of us are aware that people have their own fears, but the minute you are not willing to own up a complaint, that itself for the person receiving it makes it feel that this is a non-serious complaint. What happens is that when we receive such complaints, we try and verify it. If we can't verify it, we still take the content of the complaint and we try and examine if there are issues which it is raising, and we try and go into the details of it. But an anonymous complaint means we can't go back and seek any clarification or any further details. So actually, an anonymous complaints, especially now when we have a whole mechanism which is PIDB, which is protection of information based system. So any whistleblower can just write PIDB on the cover of his complaint, and it becomes our responsibility to protect his identity. With so many systems in place, the minute you make an anonymous complaint, it loses the steam, so as to say. The second category of complaints which are coming through the whistleblower mechanism, which are actually harming it, are the irrelevant complaints. So, you not analyzed what is the problem. You have a problem with a particular bank. You write to the manager of the bank. Then, as a whistleblower, you're not satisfied. So you write to the RBI as a CC. Then you realize, no, maybe it is also SEBI. So you write to SEBI. Then you write a CC to BSE, and you say that, just delist the company and ask SEBI impose a penalty. In the process, the whole crux of the problem is lost because you have spread yourself so thin. Sometimes the CC, which is marked in a complaint, is to the tune of 100 email IDs. Either you have really come up with some systemic issues which can change the world, and this something so groundbreaking that everybody needs to read about it, or you have just been careless about it. You just marked CC to everybody. This whole CC culture, copy to culture, is actually harming, and it's very difficult for us on the receiving end to separate the wheat from the chaff, and so much of time and energy of an organization goes into figuring out if this is worth investigating further. Next comes grievances. I am unhappy in this organization as an employee, or as a customer, I am unhappy with the policy of this organization. I start writing complaints. I use the word whistleblower. Again, you've done a lot of disservice to this whole policy by bringing your dissatisfaction with the policy and systemic issues. So why are you giving me 5% dividend? But it was always 5%. So and so is giving 7%. Then you should have gone there, right? I mean, please make an informed choice. And unfortunately, now organizations, because of the sheer number, are forced to brand such complaints as chronic complainants. So, without giving the names, we have had people who have given 400 emails in a day. Now, it's impossible for anybody to spend that kind of resources, and then they become chronic complainants. Then you're going in a different direction. So they are again doing a lot of disservice to the entire policy. And lastly, I would say the motivated complaints. So these are again claiming to be whistleblowers who are settling personal scores, or because their uh, claim has not been honored, or what they thought they should have got as per rule has not been given to them. They keep on complaining about something, and this just means that the resources of the organization are getting diverted into something which is not bringing any value to anybody. For us in SEBI, we take whistleblowers very seriously, especially when market intelligence comes to us. We examine it threadbare. But if we are going to be continuously hounded by people and frivolous complaints and motivated mischievous complaints, it gets really difficult. Whistleblowers is actually a policy which is giving a safe space, a public space. It is creating that opportunity for the organization and the individual, outside or within the organization, to have a healthy interaction. If we continue to misuse this policy, then we are actually harming it. We are blunting the edge. And a whistleblower is like you could say, the ears and the eyes of any organization. So let the eyes and the ears actually make us hear and make us see something which at the top management or people who want to really run the system well are not able to see for themselves. Please be that voice. That is what the whistleblower policy is meant to empower and meant to grant. And so I'm sure there's going to be a lot of discussion as I could see the eminent speakers. But I think while we talk about the whistleblowers, we also need to talk about the organizational perspective. Because finally, an organization is meant to give a particular service or a particular product. An organization's main purpose is not to keep replying to communication which is coming like a floodgate. So I hope this message is also uh, sent through all the discussions. I hope this is also a perspective that gets discussed in the coming 2 days, and it looks like a very impressive set of people who are going to be speaking very exciting topic. And thank you for having me over. Thank you. Jai Hind.
Thank you very much, ma'am, for having you with us this afternoon and for enlightening all of us, all the participants over here. And may I request Mr. Vijay Sachdeva sir to please give the concluding remarks and vote of thanks. And before that, you may invite some interactive discussion if the amenity speakers of the inaugural session, they may have some questions in between. Over to you, Mr. Vijay Sachdeva sir.
Sure, Santosh. Thank you very much. And while I had prepared a concluding remark, but let me say that let me thank at the outset our special guest, Ms. Whitaker, and adding to the sensation for the event today that SEBI receives 30,000 complaints daily. So I think that really creates a sense of sensation and also the importance of this vital topic. Having said that, I really appreciate how Ms. Whitaker described the categorization of whistleblower complaints and how it can be used as well as misused. And it works both ways because it is adding to the important time and energies of the relevant departments, may it be SEBI, stock exchanges, regulators, and as very rightly highlighted, that it's a policy seen quite at a senior level at the private corporate house. So if it has been used and misused, I think, as very rightly said, that we are blunting the edge. So we hope that that has not been done, but in the practical world, I think we have to live with that. But still, quoting what Gandhiji said, that even if there are 1,000 culprits but one innocent person, the law should save that one innocent person. So amongst these thousands of complaints, if there is one which can really be groundbreaking or really important, I'm sure the regulators do justice to that. And hearing from both the stock exchange and the markets board, I'm very pleasantly happy that the regulators do look at it very, very closely and carefully. So, adding further to that, Haldia sir, we definitely take a note of your valuable suggestion. We will take the key notes of this event and try to put up a white paper on this. And more importantly, on the theme of letter and spirit and effectiveness. So these are the practical insights which will be very, very helpful. With this, let me thank all our panel members. At the outset, our special guest, Ms. Yatri Devi Vitikar, Mr. Neeraj Kulshestra, CA Dr. Ashok Haldia sir, our dear friend and colleague, Mr. Hemant Sai, for your valuable inputs. And we have still a couple of minutes to spare, and being all the key members here at the inaugural session, if any of the participants, guests today would like to put certain questions, maybe we should be able to take a couple of them in the available time. Santosh, are the audio boards open or you
So,
want?
for participants, we haven't opened. We have closely retained within the panel only. There is a questions are coming from within my team as well.
Sure.
Maybe addressed by Madam Yatriji to please consider, with my humble request. As our team was analyzing some references and records, we noticed that Central Vigilance Commission, they frequently come up every year with a detailed report on how many complaints received, how many complaints disposed of, how many appeals came in forward, and then what was the rate of disposal. But the team could not find any such references in terms of the numbers. Of course, you mentioned 30,000. Mind-blowing numbers. How do you handle this? Is almost a big, huge amount of information and the complaints you receive. But is there any mechanism or the process in place wherein this all the complaints, how many were received, they were anonymous, they were with their identity they submitted, and how many were disposed of? Like this, is there any publicly available information for just our reference and internal consumption on to evaluate that how the corporate governance can be further, the stakeholders in the corporate governance can be sensitized towards better practices, and what can be your suggestions in that regard? So your comment maybe in this regard.
So just to begin with, just a small clarification. 30,000 are the kind of total communication that we receive in SEBI. It is not the Central Vigilance Commission.
Okay.
So these could be various forms of communication. They could be people coming up saying that my registration request was pending. It could be that there's corruption. It could be that so and so Sahara Securities has taken away my money. So it could be, it's like a bunch. Okay. And then we start sorting it out. So we start sorting it out into who is dealing with what. And then each department looks at which are anonymous. First of all, it is coming from an email. So we try and go back to the email and ask that, can we have all your details? And some people choose to share their details, which then makes it a proper complaint and we register it. And that is how we do it from the vigilance perspective. Coming from the CVC portal, CVC has now come up with a whole portal, which is there, which is quite widely publicized on its own website, which says that anybody can log in and create, give his own or her own complaint. Again, CVC is even more strict about not dealing with anonymous complaints. So if you don't verify your identity, then they'll just take the input and pass it on as intelligence to be checked. But if you want your complaint to be treated as a complaint, to be taken to a logical conclusion, and to be told at the end this is the outcome of your complaint, then you will have to verify your identity. So the number of cases at CVC would be, cases which are all across the country. So I would not like to hazard a guess of the number that would be there. But I think in the annual week that we have from 30th October onwards, for 1 week we celebrate the Vigilance Awareness Week. At that time, most of these figures are discussed.
Right, ma'am. So, is there any this particular whistleblower related complaints? Whether the sports portal does also receive such complaints, or is that entitlement given to the investors, or
So
there is-
there are two kinds of things. One is that you want to just complain to the CVC, and then you can log in into the portal, and then you just get a normal identity. And in that case, your identity is not kept a secret. Now, if you want your identity to be kept a secret, suppose you are a very low level employee in an organization, and you see a lot of corruption and you want CVC to do something about it, on the complaint cover, you just have to write PIDBI, PIDB.
Yes.
Superscribe it and just send it to CVC. And now, maintaining the secrecy of your identity, and that a lot of efforts go into maintaining secrecy so that the person is not harmed, and the identity is not revealed at any stage. So those are the two kind of options that you have.
Back to you, Mrs. Sachdev sir. If there is any question from Halia sir, from Hemant Saji, and anyone else.
No, I think very elaborate and very pointed deliberations and the address by the Mr. Dave and also Mr. Kulshrestha. The only thing is that we need to look into some kind of study to be organized, study to be carried out in the country as to what is the efficacy and efficiency of whistleblowing mechanism. It is understood and it is well accepted that there has to be a mechanism of whistleblower. We need to respect the complaints. We need to respect the whistleblower. But what really happens? That's more important. To what extent it has added value to the good governance? There are two ways it helps. One is the fear of somebody blowing the whistle itself put the management on the caution. The other thing is when somebody really blow the whistle, as Mr. Dave said, anonymous or not, or specific. In that case, a forward-looking management would look into the contents of that, as also Mr. Kulshrestha said, and would look into as to what value they just had. Now, possibly, we need to carry out some kind of study and as to what way it has really helped. If it has really helped, I'm sure the corporates would well appreciate and educate. I would just request the Mr. Dave or Mr. Kulshrestha, has there been an attempt made in that direction?
If I may just interject, I think the clear answer is any study will show that the results are appalling. It's obvious. Now, I think what needs to be done to strengthen, I think that's really where we need to focus. One point that was made by Ms. Dave is that the complaint may not be anonymous, but the person receiving the complaint has to keep that identity of the person anonymous. That is possible at CVC. That is possible at SEBI. How do you actually effect that at a corporate level? Because we're talking about whistleblowing at the corporate level right now, this discussion today. I sit on several boards. There is a committee. As an independent director, I'm obliged to ask that question. Some of the responsibility at the corporate level, when we talk about corporate governance, and Ashokji, what you said is a bit of a conundrum. A forward-looking management, there will be less chances of whistleblowing. Where there is a whistleblower or need or opportunity for a person to blow the whistle, that means there is something wrong in that management and something not quite right. So the two in any case are self-contradictory. So you need the forward-looking management. Listed companies are obliged, and they have checks and balances of KMPs and independent directors who play a certain role. But I think the corporate world where the whistleblowers are not protected, and therefore there is that inbuilt apprehension of toward making these kinds of complaints, that has to be addressed. Now, that's not there's no easy answer to that. But like I said earlier in my opening remarks, some of the retaliation is very subtle and is done very subtly. The guy potentially loses his job opportunities and all that. The one way of dealing with that is that it has to be his identity has to be kept completely anonymous. Now, how do we ensure that? What is a structural kind of a thing that we can put together? That is the question. SEBI can't do it. SEBI can play a limited role in that. Ultimately, the whistleblower is acting within the company. He has to blow the whistle to somebody within the management. How do you ensure that person's independence, the person who's receiving the complaint, so that he is not motivated to? So we have independent auditors. So can we have an independent whistleblower, receiving organization? Right? Those are the kinds of structural things that we should be discussing.
So, if I may, I just wanted to add further that as Ashokji has pointed out, that any forward-looking management would even look at anonymous complaints. That is usually what is done, that if certain facts have been pointed out, those are analyzed. Regarding how it is easier for a smaller organization or CVC to keep the identity anonymous, one of the things that we do is that a complaint in which the complainant does not want the identity to be revealed is marked as such. We encourage that information that, if you don't want people to know your identity, please superscribe it, be on top of it. And that is not opened at the lower levels. It is opened at the very top. So, that way at least. So finally, at some level, we will have to have a trustworthy person on top who will look into things, whether it is the top management, it's the board, or it's the auditors, or at some level, there'll have to be somebody who's interested in solving this. But it is possible. Such a system is possible. Or you could have your neighboring organization, or you could have a committee of a number of people who could look at these complaints.
Sure. Adding to it on a lighter note, I think we'll have to wait for technology to turn around and maybe bots or AI start working on it. Maybe that gives some sense of artificial layer in between. But answering your point, Mr. Sai, there is one sort of solution to it is independent hotlines, which many corporate use. So there are hotlines or emails which are maintained by agencies, which are completely outside the organization. And there are specialized teams who receive those complaints and so on. But why I said partially, because eventually that organization will also compile those set of intelligence and summaries and float it to some spokesperson in the organization. So I think it's still an evolving process, and that is where the production rights, and as Ms. Dave rightly highlighted, that the significance at the same time, the framework, both have to go hand in hand to make it practical success, so as to say. Great. Thank you. Thank you to all panel members and to all delegates. Santosh, would you like to move as we are on the time? We are 5 minutes ahead of the schedule. Would you like to announce and start with panel 1, headed by our senior member, Dr. Ashok Haldia, sir?
Yeah. Yes, sir. So thank you all in the inaugural session. Those who addressed, thank you very much, ma'am, for your kind being with us. Thank you, Hemant Sai, sir, Ashok Haldia, sir, and Vijay Sachdev, sir. Thanks to you as well for your sparing your time, taking out your time from busy schedule. And now to move forward, I would invite my colleague, Ms. Ritima. She's there to please introduce the eminent panelists of the next session and hand over then the mic to session chairman, Dr. Ashok Haldia, sir.
Very good afternoon to all of you present, and keeping up with the tempo set by the eminent dignitaries in the inaugural, we kickstart the first panel for the session. So encouraging employees to report wrongdoing and to protect them when they do is very essential for prevention of corruption in both the public and private sectors. Employees are usually the first to recognize wrongdoings in their workplace. Empowering them to speak up without fear of reprisal can help authorities to both detect and deter violations. So on this note, we have our first panel. The theme of the panel is public accounting, ethics and governance, and public hearing. The session will be chaired by Dr. Ashok Haldia. Sir is Chairman, ASSOCHAM Task Force for Accounting Standards, Sustainability Accounting, and Integral Financial Reporting. We have with us 5 eminent speakers in the panel. The first is Ms. Tanushree Bagrodia. Ma'am is Chief Financial Officer, Lakshmi Organic Industries Limited. And ma'am will be speaking on whistleblower policy from the perspective of CFO. Then we have with us Mr. Robin Banerjee. Sir is CMD with Capri Hands, and so will be speaking on stakeholders' education on whistleblower policy, a way to enhancing corporate governance. The third eminent speaker for the day is Mr. Sriram Subramanian. Sir is founder and managing director with InGovern Research Services Private Limited. Sir will share his insight on shareholders' activism and whistleblower protection. Then we have with us Ms. Anushka Vora. Ma'am is manager at Vinod Kothari and Company, and ma'am will be sharing her insight on effectiveness of Indian whistleblower policy in India under the Companies Act. The last speaker, but never the least, Mr. Vishal Nirula, sir, is managing director at Alvarez Marshall and will be speaking on how to handle bulk whistleblower complaints. With this, I hand over to Mr. Ashok Haldia, sir. Sir, over to you.
Thank you very much, Ritima, and indeed a great pleasure to be amidst such a distinguished panel of representing different stakeholders concerned with the whistleblowing policy, letter and spirit vis-a-vis effectiveness. I had given my observations in the inaugural sessions, and I would not like to go much detail into the beginning of the sessions. Maybe in between the sessions and towards the end of the session, I will chip in and give my thought process and elucidate my thought process further. Let me straightway come to the topic and also invite the speakers to address that. What is that we are discussing is the effectiveness of the whistleblower policy. Is the law, what is the law on the whistleblowing policy? Is that law good enough, comprehensive, holistic? If yes, is that effective? Effective in the sense of its compliance in letter and spirit. If that is not the case, then what further needs to be done? The other thing that we notice is the corporates do receive a large number of complaints. How effectively to deal with those complaints? Because law would require them to record, to investigate, to respond to, if required, to the complainant or to the regulators. Now, how do the corporates manage that? And we believe that as a professionals, the company secretary for that matter, the role of the company secretary and the legal practitioners becomes all the more important. So all these issues we are going to discuss, and also, is the whistleblowing system being abused, or it is unnecessarily, unduly blamed to be misused? We also need to look into that aspect, and for that beginning, I would like to invite I think Ms. Tanushree Bagrodia. I think let's first have a perspective of a corporate, the CFO himself, as to how much it bothers them, how much they encourage this, how positively they receive these whistleblower complaints, and what are the system and the processes that they are involved to deal with the whistleblowing. Over to you, Ms. Tanushree.
Good afternoon, everybody. Thank you, Mr. Haldia, and it's a pleasure to be amongst this August gathering today. Mr. Haldia, before I start, just like you very rightly said, we would all like to prevent whistleblowing. And that's what good CFOs want. I also want to sort of go back to what you said in your inaugural session, sir, that whistleblower policy is not contemporary, but has been in place since the times of Kautilya. And even the Greek philosophers have said that neither laws nor judges can bring any results until someone condemns the lawbreakers. And when I look at this saying in the context of whistleblowers and the whistleblowing mechanism, it's so true, albeit with one change, that it is not really condemnation that is needed, but holding accountable. And I think that is also, when you hold somebody accountable, you put prevention in place. And specifically, it is important that those who are custodians of the effort and the wealth of stakeholders are accountable for the ethical and moral upstanding conduct of the corporate and financial reporting, legal matters, any misconduct, health and safety, environment, and management action. As a CFO, I feel that the finance function is the custodian of reporting the financials, of the accuracy of representing what the business is doing. The secretarial team is the custodian of ensuring that the company's conduct is in form and spirit aligned with the legal and compliance requirements of the laws of the regulators and the laws of the land. And the CFO is the consolidator of these units, has a significant role to play in ensuring that the governance and reporting standards meet the moral and ethical benchmarks of employees, customers, vendors, and capital providers. So it's not just investors, but it's also employees, customers, vendors, and bankers that we need to address. And in my view, this is the only way that the culture, mindset, and the intent will really be set to have effective governance and an effective whistleblower policy in place. If we look at the way the laws have transformed at the time of the very infamous Satyam scandal that happened, right? The position of the CFO was not a statutory one under Companies Act 1956. And with Companies Act of 2013, this changed, and both the CFO and the company secretary became KMPs. Now, these bring in not just legal obligations, but also liabilities for the KMPs. And these provide a framework for us to operate in, and they also are a deterrent in some way. But I think nothing can actually supplement individual accountability. And I think to that extent, the CFOs of both listed and unlisted companies have the moral accountability to be able to ensure that the final and legal conduct of the organization is well governed. Now, the law will prescribe rules of audit committee being the reporting and maybe the investigation body and so on. However, in my view, the preparation of having a preventive maintenance and an effective policy starts at a very granular level. The finance, legal, and secretarial teams under the CFO, and I'm speaking from my experience, need to have the teams, the low-level teams need to have the confidence of being able to highlight any errors and mistakes well in time. Because if you don't highlight errors and mistakes, you keep trying to cover those up. At some point in time, it will lead to misrepresentation. And I think this safe environment will ensure that not only inadvertent errors are corrected, but it will also have teams, because it's the it's the finance, the legal, and the compliance teams who have early indicators of within an organization of something that's potentially going wrong. It will allow them to speak up. And alluding back to when we were saying that anonymous complaints lose the seriousness, if at the granular level the teams have the confidence of being able to speak up, we will tackle with the situation early on, and we'll be able to get all the evidence and seriousness to investigate the matter. It is, it is a responsibility of all in the organization to have a safe environment where speaking up is encouraged and not reprimanded. But I think the CFO and the finance teams need to be more vigilant and, if I may say, more proactive in this. And thus, this is the first step, in my view, in preparing to providing the teams the freedom of expressing and disclosing an error or something that they find to be uncomfortable. From a CFO's perspective, of course, we need to have the requirements of Companies Act and LODR to be drafted and deployed on ground, not just in form, but also in spirit. But this also means that, we utilize the two pillars we've been provided, the audit partner and the audit committee chairperson, very well. And in my view, as a CFO, there should be a direct channel of communication between these two individuals so that they can have an independent discussion, and any concerns that each one has can be looked into with a fresh pair of eyes. To ensure that the CFO can be an effective agent in a company's integrity and ethical conduct, the one tool I think the CFOs have at their disposal is the internal audit. I think internal audit is an aspect which is extremely valuable, where very detailed review can be done and visits can be done either by the CFO or very, very senior finance team members, so that, the ability to understand the plausibility of an anonymous complaint being true can actually be verified. And I'd like to share an example which I encountered as a banker, which is where, if you really go to the most vulnerable areas and have a detailed review, you potentially can understand whether an anonymous complaint is true or not. So I was helping a company raise money, and for some reason, this company was not willing to share their projections. Now, we had to make our own projections to be able to tell investors on what the growth path of the company was. Now, to ensure that what we were representing to investors was accurate, as bankers, we visited the sites of the company. And what that revealed was a significant amount of dissonance between reality and the company's claims of future growth. What I did was I stalled the pace at which we were going for the fundraise exercise, because it was a reputational issue for the bank that I was working with. Very soon, we actually got to know that there was an anonymous whistleblower who had raised a complaint that the company in question had been fudging their numbers, and this was a listed company. And the complainant had actually said that, I would have understood if it was 10 to 20%. I'm actually bringing this up because it's up to 200%. This was in 2011. And at that point in time, we got a call from the forensic guys who were looking into this. And because we had visited the site and we had some amount of insights, we could actually provide feedback that was valuable. And thus, I think a detailed oriented approach by the finance team, encouraged by the CFO, can put effectiveness of prevention and solution of complaints in place. I think we can all talk about the good things the CFOs can and should do to prevent events that lead to whistleblowing. However, in the event of such an event, I do believe that the CFO, the company secretary, and their teams should be supportive of the investigation. We discussed in the inaugural session that timelines should be put in place to ensure that the investigation is done when the complaint is fresh and the complaint is resolved at the earliest. This also builds confidence across stakeholders on how serious the organization is on its governance standards. And this is also what Mr. Kulshresht referred to in the inaugural session. On this, I will share one other experience that I have had. When the company I was a part of received an anonymous complaint of harassment and unsafe workplace. It was not a posh complaint. It was just a complaint of harassment and unsafe workplace. The company in question decided to do a deep dive investigation. And as a part of that, what came across was that there was a conflict of interest, a financial conflict of interest between the person against whom the complaint was raised and the company. And this person was a relatively senior person in the department that he was with. Once this was discovered, it helped the company take appropriate action to ask the person to leave. The company spoke about the standards that are expected from employees and what are the values that the company stands for. And it actually gave a lot of confidence to all concerned that, the company will take action and governance is not just something that the company talks about. But in all of this, I think the big challenge really is to look at, and we again discussed this in the inaugural session, and as CFOs and as corporates, one faces this, right? How do you look at complaints that are genuine, that are not being raised just to create sensationalism or because there is a vengeance or a revenge motive behind it? How do you look at these complaints and ensure that no harm is done on either side? And in the case of a listed company, if such whistleblower complaints become public, then I think it's even more important to see how to communicate both with internal and external stakeholders, especially in the age of social media. How much to communicate, how to communicate. And Ms. Dave referred to how does one control the sensationalization that gets created. And I think that is something which makes life of corporate leaders and CFOs a little more challenging in the context of a whistleblower environment. To end, I'd basically like to say that we should all, of course, have the right policies, frameworks in spirit and in form. Having said that, I think culture eats strategy for breakfast, and we have to set the right culture, mindset, and intent within our organizations for prevention and to ensure that if a complaint is raised, we take it seriously and it is investigated deeply and within a certain timeline. Thank you.
Thank you, Ms. Tanushree Bagrodia. Indeed, you have covered in a very, very limited time comprehensively how does a CFO looks into and should look into, and how comprehensively, holistically the approach a CFO should have, and very positive way that you have outlined for the role of the CFO. Thank you very much, and indeed, we'll come back for more questions to you. And let's now move to Mr. Robin is not going to be with us. He had certain contingencies, and he may join in between, but then he may or may not join us. We have Mr. Shriram, who is based, who is with the research organization, and very, very important organization from the whistleblower or the shareholders activism perspective point of view. Now, my question, I would like him to give some light on to how to differentiate between a shareholder activist and a whistleblower, and how does these two conflict or can become together in order to in order to enforce the tenets of the corporate governance. And the second thing, since he's a research-based in the research-based institution, does he any idea as to what is the approach in reality the SEBI does follow on the whistleblower complaints? Over to you, Mr. Shriram.
Good evening, good afternoon. Thank you for inviting me for this webinar, and I'm happy to speak here. And so firstly, you've asked a very pertinent question that can a shareholder activists work with whistleblowers, or the other way around, can whistleblowers work with? What is the motive of any whistleblower? The need for whistleblowing occurs because they want change, some positive change. They see something rotten within the organization and they want some change. So that is precisely the reason why even the shareholder activists are also working. So from that perspective, their objectives are similar, right? I mean, so if you look at the recent case where I would think Infosys had whistleblower who said that Panaya acquisition in this is of 2014-15. I'm talking about where, and then subsequently the shareholders of Infosys then subsequently chose to act on it. Obviously, Infosys is a US listed company, so the pressure is much more on Infosys. And subsequently, the board did take cognizance of the whistleblower complaint. It was all over the media. And so I think there is definitely alignment of interest between a whistleblower and a shareholder activist. In India, unfortunately, shareholder activists are not recognized shareholder activists or investors. There are not many hedge funds who will take a long short kind of position. So it becomes a slightly tricky thing. Whom does the whistleblower approach? And that's where, if you see, we as proxy advisory firm, we get anonymous letters. In the case of West Bank, for example, before Mr. Rana Kapoor's shenanigans and fiasco happened, much before that. But we are unable to act beyond some level. We can at best direct them to media, we can direct them to SEBI, or even in some cases we have made formal complaints with SEBI. But there is only so much that can be done unless one has a position in the company itself, that is a shareholding and an ability to bring about change. So I would like to see the day where whistleblowers also take heart in thinking that the outside shareholders will also support their efforts, and that's where come about. And I mean, whistleblowing, of course, has many areas. There could be, as somebody said, an unhygienic workplace or some unhealthy workplace, which is more of an operational issue. But there could be something like a financial, this one, or embezzlement, etc., which is much more concerning the shareholders. So I think there is definitely interest from that perspective. Mr. Haldia? Hello.
Any thought on the approach that the SEBI follows on the whistleblower complaints and how effective that approach is?
Yeah, I think for now, if you look at SEBI's this one, I don't think it has been very effective. SEBI has a reward program, but it is not as effective as the one that SEC in the US has. And the rewards given by SEC are really, really huge. So from that perspective, whistleblowers can take the risk. In India, SEBI relies largely on the scores system. If it's a very formal complaint, and the score system, invariably they direct the complaint to the exchanges and in turn the company. So which is a sort of SEBI by itself does very little investigation, even in serious cases. Is unfortunately SEBI doesn't have. I have always said this, that capability and capacity both sort of is lacking with SEBI, and so it is very whistleblowers are disheartened when they approach SEBI, and that I think one is SEBI needs to offer higher rewards. Two is somehow SEBI needs to sort of enhance its investigative capabilities.
Yes, thank you very much. And in fact, given the number of complaints that the SEBI does receive, or the communication that the SEBI does receive, as Ms. Dave clarified later on, it's also a very Herculean task for the SEBI to deal with some, to filter them out and then take the effective steps. So I believe we need to use the artificial intelligence or some kind of a technology interface to be able to effectively deal with such large number of communications. And coming to you, Mr. Vishal Narula, the Managing Director of the Alvarez and Marshall, thank you for joining us. And the point that you may like to reflect upon is in terms of as a company, you receive lot number of complaints or the whistleblower complaints, and then becomes difficult as to filter them out. And this is what we also discussed in the inaugural session. So how do you deal with that scenario?
So thank you, Mr. Haldia, and I hope I'm pretty audible for passing on the mic here. It's a very, very important concern for most corporates, especially because of the changes in regulations that have happened now in India. Basis which all the whistleblower complaints that are received needs to be substantially disposed of with, even if they are not all investigated, but you need to find a way of whether or not you investigate something and why. So just imagine an organization in which you would receive over 200 whistleblower complaints in a month. That is an average of 9 complaints every working day of the week. Uh, what kind of a team would you need to be able to investigate each and every one of them? Because if you land up investigating on an average, the smallest of the matters that we investigate as a part of A&M disputes and investigations practice takes roughly 3 weeks to be able to gather facts, to be able to conclude everything, report, find the implications of it, also find mitigations after the investigations are over. So it would take a Herculean team just to be able to review and investigate every single whistleblower complaint. So we'll keep the discussion aside on why would an organization receive such a high number of complaints, because the number 200 that I mentioned is a number that we see day in and day out in large corporations that happen, especially when the organizations have very sound programs around ethics and integrity and compliance. Because the speak up culture that has been instituted by a lot of the multinational organization and very large Indian corporates, using trainings, reiteration of the same through communications, and reinforcing tone at the top, which basically means that the leaders actually walk the talk, and putting in a lot of measures to bring about openness and transparency with respect to the health of the ethics and integrity of the organization, has made sure that people have become very well aware of the different ways in which they can raise concerns. They have also understood that most private organizations prefer to keep anonymity of whistleblowers intact, which means they can report through anonymous email IDs, through anonymous phone numbers, or by just dropping letters in boxes without really revealing their identity. Now, when all of that is there, an organization with the right intent who would like to make sure that all genuine concerns are investigated will obviously be inundated with the high volume of complaints that is now that it gets. More so, it will create a dilemma for the ethics officers, because they would be the final custodians of these complaints and responsible and accountable to ensure that all genuine concerns have been investigated, have been addressed, and then they have to satisfy the various disclosures, the various compliances, and the various questions that they would otherwise get. They also become those conscience keepers who then help an organization evolve into a stronger company, where they are able to plug through such issues so that you are not getting a lot of concerns. But the key always remains on the kind of concern that comes, whether that is genuine or not genuine. And you have to be very objective and impartial without bias to be able to assess whether a concern is genuine or not. So the manner in which one needs to prioritize as to how many complaints do you review and how do you review them really comes down to each organization's inherent vulnerabilities, the kind of environment that they operate in, and what has been the past trend of them receiving similar complaints. So I can share with you some best practices that we come across from the different organizations that we work with. I think the one thing that most organizations try to do pretty well, and ensure that they are not compromising on, is making sure that there is constant engagement with whistleblowers. And for that, if possible, they also engage external agencies that run hotlines as a service, where a lot of things can be taken care of. For example, multitude of jurisdictions does not become an issue, because you could have hotlines that could have different ways of recording complaints, such as emails where you can send complaints 24/7, voice recorded messages that can record your voice 24/7, or mailboxes in that sense. We have also seen organizations have external hotlines where you have individuals who will physically sit down and meet whistleblowers to jot down their complaints. And a lot of these agencies also have multilingual capabilities, so that people from different jurisdictions, and if you're in a country like India, every state is a different language speaking state. So you need at least 20 or 30 different languages or dialects just in India, but at least service the 8 or 9, 10 common languages, in which the kind of workforce that you employ. They use such services of hotlines to be able to ensure that there is constant engagement. So if you receive a complaint by email, you could respond by email acknowledging that the complaint has been received, the concern has been noted, highlighting the different kind of policies the organization has, what are the other venues that a person has in case the person is still not satisfied with the concerns raised, and helping, and then asking the person if they would be comfortable responding to a few more questions, helping gather more specifics around the complaint, while keeping their identity intact. Well, if they've disclosed it, it remains masked. If they've remained anonymous, then so be it. And such engagement helps in understanding what is the real issue behind the complaint. Is it something that is as serious as shareholders or as internal people raising concerns on the whole projections of the financials of the company that Tanushree just mentioned, or about senior people being involved in unethical activities or illegal activities, so as to say, something that can really damage the company, its brand, and attract a lot of regulator scrutiny. So it helps in understanding the kind of issues that are there. Then it also helps in understanding the kind of people that would be involved, their level of seniorities, and what would be the danger level of investigating such a complaint. Then it also helps in understanding the key areas involved, whether this would have an impact only on the financials, whether it could create regulatory impacts, brand reputation impacts, and so on and so forth. So you would also know whether it's going to be limited to one single department in an organization, or it could be an organization-wide activity. And then all of these inputs gathered together help in understanding what could be the impact of an activity which is being alleged being a genuine concern, and if that's ongoing, how would that impact the organization, the brand, the reputation, shareholders' confidence, creditors, and so on and so forth. It helps in prioritizing complaints using the knowledge of all of these things to understand whether the complaint needs to be investigated right away, or it needs to be referred for a preliminary inquiry and then for a detailed investigation, and so on and so forth. But organizations where they receive 10 to 15 complaints on a single day basis, and there are organizations who receive even more than that, have even more robust proactive systems in place, mostly driven by technology. And all of them would like to filter down complaints using a risk model. Now, they try and assess, using the inputs that I just mentioned, whether something has regulatory implications first, because there are very different laws and very different requirements of different statutes with respect to things like frauds or misconduct or ethics and integrity. So the first thing is to find out whether from a regulatory point of view, what are the different implications. Mostly after that, a company tries to see what would be its implication on the brand and reputation. So what is the risk to the brand if a complaint like this gets investigated after a point in time, or does not get investigated at all. Then it sees what would be the financial implications. and understand if there is a loss to the company, if there is a loss to someone else because of the company, because of which the company could have an indirect regulatory implication or a reputational implication in that sense. And then to see whether the people and the operations of the company will suffer or not. So a risk grading is usually followed by a company. To arrive at the risk grading itself, our organization needs to carry out a lot of internal exercises, like Tanushree mentioned about strong internal audits. But understanding just weak controls is different from understanding fraud risks by themselves. So a lot of organizations who are really, really large and have large teams on ethics and integrity with, who also have a huge volume of complaints that come in, carry out thorough fraud risk assessment exercises and try and see if there are different ways in which people inside and outside the organization can game the system. When I say game the system, I'm saying that in a very loose way, because it's a way of saying that if your organization is intact, whether people inside and outside or in collusion with each other carry out a fraud, that will go undetected, and that would be in spite of all the governance and internal controls and monitoring exercises that you would be carrying on. So keep your organization as is, and let's see if a fraud penetrates your organization, very much like ethical hacking, but not just in the field of IT. It could be on everything and anything that the company does. So you understand what are the vulnerable areas of your risk. When you've identified that, you can then map complaints to risk areas faster. You will therefore know that if you receive a complaint about an area that we already are aware of that is vulnerable to fraud, what do we need to do to review them in depth faster? That helps in prioritizing complaints over a large volume of complaints. The other thing that we see organizations do is that if they've identified a fraud or a concern to be genuine in a certain area, and the mitigation of those risks is ongoing and not yet complete, if they receive further complaints in that area, they get automatically prioritized, right? They also prioritize complaints where they have seen confirmed issues in the past. Even though organization would do the best to mitigate risks so that the same complaint does not come back, but for whatever reason, if a similar issue resurfaces, it would not be taken lightly until and unless there has been reasonable amount of work that is done that can ensure that the same issue cannot recover at all. So that is another way of kind of prioritizing what kind of complaints needs to be picked up first. The other things could be, a slightly more generic and more aligned to culture. And when I say more aligned to culture, I would say if something comes as an absolute surprise, so let's say an organization is extremely strong on its financial reporting, and even from the point of view of, say, shareholder advisories, it's not been in the light or ever before, and something suddenly comes up about it with a reasonable amount of specifics, it will definitely not go unnoticed because it will stand out. And that also depends on the culture of the organization and of the teams that are handling in ethics and integrity, which means that if for one of the best rated companies in the world, if there is a strong complaint on financial mismanagement or financial reporting, no one will take it lightly, because the risk of that leaking out to the media or in social media and then going viral and then creating a huge brand and reputation issue is humongous. So they would not take that and park that aside to say, we know we are really strong and therefore nothing can happen. But it also depends on the people and on the culture. The other thing could be the kind of people involved in it. So for example, if you have a very well governed organization with lots of segregation of duty, which has a very good tone at the top, where you have a lot of different ways to check and cross-check what everyone else is doing, a very sound track record of, say, a company investigating complaints, taking action, communicating the results of his action. If in such an organization, if you see that the key people who take care of ethics and integrity are under a scanner, then also it will be a very huge surprise. And huge surprises would definitely not be dealt with lightly by some of the organizations, because they would want to make sure that that you continue to have that high level of governance, so that you're not kind of doing a self goal there, in the season of soccer. Let me use that analogy. So these are very different ways in which organization prioritize, slice and dice the complaints that they get, put them over a risk matrix to see where are you more vulnerable, where are you less vulnerable, and then eventually land up investigating those that really, really matter first, and then land up investigating the rest, where you still want to make sure that you're not missing out on anything in that sense. So you don't want to wake up one day and say that we had received a complaint like this in the past, but it was just one and it was not very specific. We wish we would have investigated, and therefore a miss there. So there are, of course, a lot many other ways of using technology, but I think in the interest of time, let me just pass the mic back to Mr. Haldia to see if there are more inputs to be shared later.
Oh, Vishal, you certainly took considerable time, but that you touched upon you related the complaints to the risk, and then slicing out an approach for the management as to how to prioritize those complaints. And that's very important point that you highlighted. In fact, in your address, in a way, have addressed some of the questions that lies. Those are from the audience. So thank you very much, and in fact, very, very comprehensive, a different perspective altogether. Now, let me come to the Anushka. I think something which we should have taken perspective in the first instance, but then I thought that we should first have a look at the different stakeholders, the company, the research organizations, the CFO, and then come to the fundamentals of the law itself. And she is I believe, is a company secretary and a legal practitioner. So can you throw some light, Ms. Anushka, on on what is the framework of the corporate law, and what is the perspective behind that framework?
Thank you so much, Mr. Haldia. I hope I'm audible. Hello, everyone. It feels great to be a part of, to be among such eminent speakers. So I also would want to share a bit of my experience I've gained as secretarial auditor. So talking about whistleblowing mechanism, it is an act of reporting suspicious activity. Whistleblower it's an invisible eye of a vigilant. Whistleblowing acts as a deterrent. Like every person, the presence of an effective whistleblowing would ensure that a person does not engage in fraudulent activity. There's a report of Certified Fraud Examiners 2022, which conducted a global survey. That report states that almost half of the frauds were detected by complaints which were received, like from the tips, and more than half of such tips were received from the employees. So as such, whistleblowing mechanism also acts as a very effective fraud detecting mechanism. Talking about the current framework which is there, so Companies Act mandates every listed companies and certain class of companies which is mentioned in the rules to have an effective vigil mechanism. Now, these companies are generally perceived to involve public interest. Talking about like the listing regulations, every listed company needs to have an effective whistleblower or vigil mechanism policy. It reads as the listed entity shall devise an effective vigil mechanism or whistleblower policy, enabling stakeholders, including individual employees and their representative bodies, to freely communicate their concerns about illegal or unethical practices. So here I've emphasized on two words, which is effective whistleblower or vigil mechanism policy and freely communicate. So with the term effective, we understand that this should not merely be a tick box approach. And when we talk about freely communicate, we understand that the protection has to be accorded to the whistleblowers. There is provision with regards to the protection that has to be provided both under Companies Act and under the listing regulations. Further, now when we say that, like Mr. Haldia also mentioned, that letter has been prescribed. So both these statutes, they cast responsibility on the audit committee to ensure the effectiveness. So it has been mentioned in the letter, but has it been complied in spirit? So practically speaking, when we do audits, we see, or also during advisory, we see the minutes of the audit committee, and we see that there's an agenda with respect to the whistleblowing mechanism. So they mentioned that they very nicely put it in the minutes that no complaint was received during the quarter, and this goes over the year, and the audit committee satisfied itself on the functioning of vigil mechanism. So we need to understand that not receiving a complaint is not a certification for the function working properly. There could be there could be instance where not even the employees, the stakeholders, they are not even aware that they have such a power. So not receiving complaint cannot be a means to say that the function is working properly. So I'll be talking about the steps which we could take in a few more minutes. Before that, I would just want to highlight on the disclosure requirements, and also a typical process on how the process should be, what an ideal process should be. So under the listing regulations, they provide for disclosures with respect to vigil mechanisms. So under the corporate governance report, the companies have to mention about the establishment of vigil mechanism, along with an affirmation that no personnel was denied access to the audit committee. Then there is, of course, the policy has to be disclosed on the website. Under the insider trading regulations also, there's a concept of informant, where again, it says that the vigil mechanism policy of the company should provide for instances on lack of UPSI, on leak of UPSI. So now, and there's, again, this was about the private sector. When we talk about public sector organizations, there's this Whistleblower Protection Act of 2014. I'll restrict myself to the corporate whistleblowing. So talking about the process, like what an ideal process should be. So a complaint has been made. Now that the person making the complaint could be an employee, could be supplier, vendor, customer. So complaint has been made. Now who is going to be at the receiving end? Now at the receiving end, there should be alternatives. For example, there could be chairman of the board. There could be a committee. That committee could be an audit committee or some independent committee, which is a delegated body of the audit committee, or the HR or some other personnel. So, like for if the complaints relate to the frauds are related to financial aspects, that could be reported to the chairman of the board. If it relates to non-financial, it could be reported to the HR. If it, for example, the complaint relates to the person against whom the complaint is to be made is the person at the receiving end, is the chairman of the board or is member of any committee, then the complaint can be made to the HR. So alternate mechanism of reporting is very important so that the complaint enters the system. Then once the complaint is received, it should ideally, like, there should be an investigating authority. The companies can engage external investigating authorities for this. Then they would, do the fact-finding exercise and inform the accused, and opportunity of being heard would be given. And then in case if it is proved correct, disciplinary action would be taken against the person. So now when we say that the investigation, like the co-panelists, they also mentioned about investigation process should be a time-bound process. It cannot be a prolonged process. So talking about like what could be the ideal time. So once the complaint goes to the investigating authority, the closure of the investigation should be done, say, within 45 to 60 days. Then there's a very important concept of anonymity, of anonymous complaints being received. Say I'm an employee of XYZ Limited, and I would want to, I'm aware of some fraud which is going on in my department, and I would want to report the same. But again, I have fear of retaliation, or maybe the person against whom the complaint is to be made is at the receiving end. So I would not want to disclose my name. So if there's no provision in the policy with respect to anonymous complaint, then again, it would never enter the system. So we went through whistleblower policies of top 10 companies, and we found out that almost more than half of the gummies, they have provision with respect to anonymous complaints, and like almost half of the gummies, they provide for the timelines, which ideally is 45 to 60 days. So like once after the process, like we have seen the process and the current mechanism, when we talk about whether it is being followed or what could be the steps to ensure effectiveness. So one very important thing is, like, it's been over 9 years since Companies Act mandated the requirement of having vigil mechanism. How effective is it? Like, how successful has it been? The success would really depend upon how freely the employees or the stakeholders can communicate their concerns. So one very important thing is sensitization. If I'm not even aware I have a right to report, or I have a right, how can I even exercise it? So sensitization and training is very important. So it should be the duty of the board of directors to sensitize the employees upon that they could even contribute to the system. Like, this is good corporate governance. They can report something which is alarming. So training program should be carried out. Then is second most important thing is, like, the function is the function which is currently in place, is that effective? Now we as secretarial auditors, we send an email to the mail IDs that is mentioned in the whistleblower policy. We send a test email just to check whether that email ID is working properly or not. It could be that, just because just for the purpose of giving the report to the audit committee every quarter on what complaints were received and has it been resolved, the email IDs are being operated on a quarterly basis only, and daily basis there's no login, or the email IDs have been jammed. So we do this practice of sending a test mail to get a revert, and of course that is not sufficient. That does not prove that the mechanism is strong enough. Then next, which is also very important, is that, like, talking about sensitization and then email IDs should be effective. Then I think the investigation process also should be very transparent. Like, the in the policy itself, the time period within which the investigation should be completed should be mentioned, and like the company can engage external investigating authorities for the same. This should also be documented. Then the committees which we were talking about, like some independent committee should be there, or even if the audit committee is there, or whatever alternate mechanism of reporting is there, the terms of reference of such committees should be properly documented. And again, when, like, the next thing could be done is there should be appropriate disclosure in both report. Currently, what the listing regulations and Companies Act provide for disclosure, apart from that, there could be, a statement like of like this annual report on CSR. Similar to that, there could be a reporting where the board reports how many sensitization or training programs were carried on during the year. Then I think Mr. Narula also mentioned very effective ways of mapping it with the risk. So there could be many, depending upon the organization and depending on views, there could be so many like effective ways to go about with it. So that was my views on the effectiveness and also the steps that we could take. Thank you.
Thank you, Ms. Anushka, for elaborating the perspective, the legal perspective on the whistleblowing mechanism. Obviously, there is a question of the compliance as per law, and also effectiveness in compliance. Both are two different things. And what we notice in reality is this compliance in law. And it's not only in respect of whistleblowing mechanism, but also different facets of the corporate governance. And that's indeed something which the corporates, trade and industry association, regulators needs to ponder about. The law can give you the framework, the boundaries and guidance, but ultimately It is for the individuals and management to implement. You rightly said that the sensitization has to take place. Of course, the corporate managements do sensitize and all the employees at all levels about the suggestion schemes and then rewarding the suggestions, but not in the form of the complaints. I don't think there is a mechanism in the corporates which would reward a whistleblower. Whether it should be whether there should be a mechanism by the corporates to reward the whistleblower or not, that's something to be debatable. But certainly, the regulators have a role to play therein, as in the case of the SEC and also in India recently. So we need to look into as to in terms of how to be sensitized and how to be reward and how to be motivate and how to be protect. And what is importantly at the same time is that the whistleblower mechanism used for the meaningful purposes and not for frivolous purposes. And how do we differentiate in reality these two aspects? Now, the another aspects of the efficiency or the effectiveness is the secrecy of the complaint is made. Now, is that possible in the system that we work? Whether the technology has a role to play into that? And thirdly, more importantly, while you can mask the name of the complainant, but the content that the complaint would have can indicate as to who is, or the subject matter of the complaint can indicate you towards the complainant, and that's good enough for the person to retaliate against whom the complaint is made. So these are the reality, these are the real and the practical aspects. In fact, the Ms. Vian has posed a question that it's difficult to maintain the secrecy because the way the complaint is drafted, the subject matter of the complaint, the references made in the complaint might give enough indications to individual as to who is the real complainant. Now, how to deal with that? How to deal with that situation is also a challenge for the management. Ultimately, the management has to see value into this. The regulator has to see value into this and find out the appropriate ways. With this, I have there are some questions coming into raised by the audience, and while some of these have already been answered, but if Mr. Vishal, if you can elaborate more on how the technology can be used, what kind of technology tool and techniques are available to effectively deal with the whistleblowers?
There are enough and more tools available these days where, specifically to record whistleblower complaints, where as soon as a complaint is recorded there, so let's just say the complaint is through an email, the email ID is automatically masked by the system, and the system also identifies words that look like names and starts anonymizing them. So if, say, the complainant has put that my complaint is against Vishal Narula, it would identify Vishal Narula as a name and anonymize it to Mr. A. You know, the very purpose of this is to make sure that as soon as the complaints that are received, as soon as a complaint is received, it does not become a witch hunt exercise to track down who's raised the complaint and then judge whether it is a genuine complaint or not. The whole idea is to keep every complaint under such independent eyes that each one deserves attention in that sense. Then there are also structures. If I talk about structures, and I did elaborate on them, whereas when complaints are received after the names are anonymized, the reporting of such independent ethics committees is to someone senior at a board level, mostly independent directors, so that people who are involved in the operations don't start finding out through their channels what is really happening. But I must say, and one of the earlier questions that had answered had this comment as well, that sometimes the nature of the complaint is such that that information can be available only with one person in the company. So it sometimes becomes very, very difficult to not be able to identify people as well. To mitigate that, it is really important to have the right structure to investigate complaints. For example, the audit committee chair, if the audit committee chair gets an investigation instituted into financial mismanagement of a company, uh, he need not reveal what the actual details are, but just to say this is a scope that needs to be given to an external investigating agency, an
Vishal,
independent lawyer or someone.
Mr. Vishal, the issue is that it is not that the name of the complainant is to be kept or is to be kept secret, but the person against whom the complaint has been made should be kept secret till you are able to prove that the complaint is right, because otherwise it might become the whistleblower mechanism might be used to harass the honest individuals who care for their reputations and integrity. So that's again a very important aspect. So normally we talk about the secrecy of the person whose name, I mean, complainant, but also I think it's important that unless the complaint has a substantial evidence or the complaint is proved or leading to concrete evidences, the person against whom the complaint is made is also kept, and that you rightly said that those names are also masked. The another important aspect from the which is often raised by the corporate managers is that and as you rightly said, some of the companies receive 200 complaints in a month. Now, does it lead to bureaucracy? Does it delay the decision-making process within the organization? Because everyone become cautious of the complaints flooding in. Maybe the person you do 10 right thing and you do one wrong thing, the complaints would be flooding in. Now, how do you deal with that? That the corporate managers often feel that the whistleblowing system is often misused and it leads to bureaucracy within the organization and slows down the decision making process. I think they have merit and they have also not justified in their complaint, because if the governance doesn't mean the delays, the governance means only good governance means only proper management, and the things to be done timely, properly, comprehensively, holistically, and if that is done, then possibly the whistleblowing mechanism has a very positive and productive role to play. So it is not fair to blame that the whistleblowing mechanism does lead to bureaucracy or delays within the organization or slows down the decision-making process. So any comments from you, Mr. Shriram or Ms. Anushka? Mr. Shriram or Ms. Anushka?
If you don't mind, I can add a comment over there while Mr. Sriram and Anushka gather their thoughts.
Right.
So I think the whole process that I explained about continuous engagement with the whistleblowers to be able to gather specifics about the complaint, specifics about the area of the complaint, the people involved, and how many facts are there to support it, really helps in understanding whether or not a complaint needs to be deeply investigated and whether it has merit or not. And if it does not have merit, and if you see a lot of repeated complaints coming, an automated risk-based system will start grading them as low priority going forward, using a lot of ML tools where what I'm saying is something that is not a proposed idea. We see these tools in practice day in and day out. We have tools that start grading complaints as they come in, because if in the past a certain type of complaint has been graded as not conclusive or not specific enough to take forward or false, it starts grading such kind of complaints in the future lower, and it does not dispose of complaints. So for example, it happens at appraisal time. We see a lot of complaints coming during appraisal times against managers. And some of them are soft in nature, some of them combine their business activities with their softer aspects. So it becomes really difficult to judge whether you should or should not investigate all of them, because it's also appraisal season, and people really get dissatisfied around that season. So where you have more specifics, they become those topics of investigation, and when there are less specifics, they don't. And therefore, the managers against whom the complaints do not also always, if there are 100 managers against whom complaints have come, one or two are, or three or four are getting investigated because they're very specific and they merit an investigation. It does not create a feeling in the whole manager pool that I should be safe and not do appraisals properly. Otherwise, in this season, there will be a complaint against me. It does not happen, So it really depends on how you filter out the complaints and then take them forward to investigate them. Also, sir, I just want to say that the people against whom complaints are done, their identities can always remain secret. Obviously, it's when I say always, let me just say 99% of the times, because it really depends on how the investigations and the inquiries are actually conducted. So in a lot of the large listed companies where we've done work, we've seen the head of the audit committee just give out certain specific steps and areas in a scope to an investigating agency. And even the investigating agency does not have the names of the suspects, so as to say, and says you need to investigate these 4 issues and come back to us with facts. So it is possible to keep anonymity on both complainant and the target side, and it also is very case to case basis.
Thank you. I think great and comprehensive. Ms. Anushka and Mr. Sriram, any thoughts?
I think yes, what Mr. Narula mentioned, that when the person on whom the accusation has been placed, when we are giving the case for investigation, it is not necessary to disclose the name. I mean, it would not serve any purpose also. What is important is this, what fraud has been pointed out or what complaint has been received, the investigating authority can carry it out. When we talk about the identity of the complainant, then of course, if we have a proper mechanism where only the head or the top management only receives the complaint, and this is a specific ID and specific dedicated person who receives it, or a committee, then of course that anonymity can also be can be protected. The identity can be protected.
Thank you, Anushka. You know, one thing I often heard saying, particularly public sector managers, being conscious or afraid or being fearful of the complaints or the whistleblowing complaints by their subordinates. They often say, they often follow the principle, I am okay, you are okay. And that's the principle they would do. Rather than taking the non-performing employees to the task, they would prefer in the phrase, I am okay, you are okay. So long you do not scratch me, I do not scratch you. So that's the philosophy. Unfortunately, that's the tendency which has been developed. And many I've heard public sector managers being critical about. One more thing that possibly we need to look into is to that can there be a common platform for all the regulators where the one complaint, if it is lodged, then a reference by all the regulators can be made, rather than the complaints going to all the regulators and centralization of those, and then all of them independently taking actions. Can that be put under the through the technology be used, and a common platform be created for the platform? So that's the one point that the possibly regulators need to look into. And the other thing is that what could be, I think we have already been reaching to the next sessions, and I see Ms. Savitri Prasad and Mr. Madan, the well-known experts, and also Mr. Vincent McWright and Vian, the international experts here, are already there. I will not take much of their time, but I would only say that the suggestions that emerge out of these sessions, one on the legal aspect, the another on the practice aspect, the third on the ecosystem around the whistleblowing system, segregated into these aspects. If the suggestion coming out of this session and the next sessions are put together, and sent to the government and the regulator, that would be a great service to the whistleblowing system. So thank you very much, ladies and gentlemen, and welcome to you, Mr. Madan and Ms. Savitri Prakash.
Thank you, Dr. Haldia. I'm so happy to see that you finish your session dot on 5:15.
I was afraid of you. I was afraid of you.
So I was feeling so comfortable that before 5:30 you're not going to finish. So I'm going to get only 1 hour, and that is going to make my job easy. But
once Miss Savitri is there, your job is not going to be easy at all. Rest assured.
That I know. That is why I've decided to put her in the end. I'm going. Her turn will come in the end of the session only.
That's how they gave the chairman of the session, and I often as a chairman play.
But I really liked your statement that you don't scratch my head or whatever. I don't know what did you say? What do you scratch? That you don't scratch and I don't scratch yours. I'm sorry, can't hear you.
I mean, you don't scratch my back and I don't scratch your back. That's what the phrase goes.
It means the vice versa is you pat my back, I pat your back.
That is I am okay, you are okay.
Yes, I am okay, you're okay. That is how this entire system is functioning. Thank you so much. And my thanks to all the speakers also of the previous session. It's a wonderful one, great discussion. Thanks to SOCM, thanks to Santosh. He's always coming forward with the novel ideas and coming up with these webinars, putting all of us together. And that's a forum where I also tend to meet many of my friends frequently. Thank you, Santosh. And my compliments to you. Really, your topics are excellent.
Welcome, sir. Learning from you, sir.
Thank you. This time you have touched this concept of whistleblower. You know, whenever you talk about whistleblower, a question mark comes to our mind whether whistleblower policy, provisions, legislation, practices, have they become actually effective? Are they being implemented in letter and spirit? Taking the box approach, I can understand. But are they being implemented in letter and spirit? Somebody just talked about that sensitizing within the organization. Is it being done? Whether the advocacy of this whistleblower policy or whistleblower provisions is being done. What is the fate of this whistleblower protection legislation? It is being said that amendment legislation is actually doing away whatever good was there in the main legislation, but the Amendment Act is nothing but is the eyewash. SEBI has come out with various provisions through this LODR. Now, whether LODR provisions with respect to whistleblower are being adhered to by the companies, whether audit committee is actually implementing this whistleblower policy, and whether the members of the audit committee are actually competent to give adequate protection to the whistleblowers. There have been many examples, many practical case studies around us, whether in the listed entities or in large PSUs or maybe in banks or maybe with some of the financial market players. But what exactly has been the conviction rate? Not even 5%. And that raises the question of the effectiveness of these provisions with respect to whistleblower. Recently, I was going through a particular case with respect to RERA in Mumbai. The one whistleblower was there. He tried to raise his voice against some of the builders or violation of RERA provisions. But after that, now he's seeking protection. Even though investigating agencies are also under pressure. If that is the scenario, what sort of whistleblower we are talking about? I'm not going to speak much in the beginning, but during the entire session, after the completion of the presentation by each faculty, I'm going to raise some questions with respect to the presentation only, because a lot about whistleblower has already been said during last couple of hours. In my session, we have CS Savitri Parekh, who is Company Secretary of Reliance Industries Limited, Dr. Taryn Mian, Professor, Director of Community Public Health Practice Concentration, University of San Francisco. We have Ms. Rajul Bohra, partner from JSA, and Mr. H. Vincent McKnight, co-managing partner of DC Office, co-ombudsman person, and whistleblower, and I don't know, it's a Quitam practice group co-chair. I welcome all the panelists, and one by one I give you a chance now. First of all, I'd like to invite Dr. Taryn Mian. Is it there on the screen?
Yes, she's there.
But I am not able to see her.
She's very much there, sir.
Okay.
Yeah, we can see.
Okay, not coming on my screen. Anyway,
Any-
so she'll speak on whistleblowing as an anti-corruption strategy in health and pharma organizations in low and middle income countries. And she's going to review this anti-corruption strategies in these countries with respect to the pharma organizations. In India also, we have very popular case study in one of the large listed pharma company, where a whistleblower was there who blew the whistle and raised certain questions on the transactions which were happening in the company. But ultimately what happened, what we are seeing, that there is going to be some sort of settlement between the whistleblower and the management. Is that the objective of the whistleblower provision, that you raise your voice and then there is going to be settlement? If settlement is the outcome, if settlement is the result, it means tomorrow we might be having number of people who actually would like to blackmail the management. There might be certain fictitious complaints also, or if they are a genuine complaint, they know it very well that they are going to get a very nice price for this. And that's not the objective of the whistleblower provisions. Anyway, let's hear Dr. Taryn Mian.
Thank you so much. Let me share my slides. I have a presentation.
Please.
Okay, can people see this and hear me? Is it okay?
Yeah, we can hear you, we can
All right.
see you. Santosh, please help her.
Terrific. Okay. This presentation is based on a paper that has been published in the journal Global Health Action. And
sorry to interrupt, Mr. And we are unable to see your presentation. Can you please check?
Okay.
Is it being displayed from your side?
Yes, I used the share button. Okay, let me try again. Now, can you see the slides?
Yes, perfectly. We can see.
Yes, it's visible.
Okay, terrific. Sorry about that. So the paper that I published in the journal Global Health Action provides more of a sectoral approach. My work has always been working in health policy and anti-corruption in the health sector. My co-authors on the study were Keith McInnes, who's also my husband, and Brianna Agnew. I just want to acknowledge them. And the reason we cared about whistleblowing in the health sector is that corruption has been related to lower health outcomes. Fraud and abuse in the United States is estimated to cost $58 to $64 billion per year, money that's not available to expand services and increase service quality. And studies have correlated the level of corruption in different countries with health outcomes that are quite diverse: infant, child, and maternal mortality, mental health outcomes, but also the injuries from traffic accidents, from natural disasters, and antimicrobial resistance. So corruption is really a big problem everywhere, but in low and middle income countries, it can be especially pernicious and pervasive. And because of already lower economic performance and sometimes the quality of government. So whistleblowing is a mechanism to detect and prevent corruption, as we've talked about already today. In the private sector, reports by employees can be detect up to 40% of the fraud cases. Figuring out the best ways to implement whistleblowing, as everyone's been discussing, is extremely important for improving health outcomes. So our study question was, in health and pharmaceutical organizations, how is whistleblowing understood and what evidence do we have about it being used as an anti-corruption strategy? Well, first we sought to understand what definitions people were using, what were the description of the models and policies and systems. Secondly, what evidence exists about the frequency of reporting, the outputs of the system, as people have mentioned already. That's important to be transparent about. Third, we wanted evidence on what factors influence an individual's decision to whistleblow. We also wanted to understand country or cultural context and how that influences the choice to blow the whistle. And finally, we wanted information on how organizations had documented the outcomes of the whistleblowing. Sorry. So a little bit about our methods. We registered our protocol. We had eligibility criteria that I've already really mentioned. We did not address research-related fraud, although that is an issue that people blow the whistle about, plagiarism, data falsification, but we were more interested in issues of corruption that affect service delivery directly. And we included 3 databases, PubMed, Embase, and Scopus, and also searched multilateral organizations' websites. Starting in 2005, as someone mentioned, this was the start of the UNGAC, the UN Convention Against Corruption. We all 3 researchers screened the articles, read them, and analyzed the data. And looking at this chart just shows our numbers that we were able to identify 206 records. Once we screened those records, 58 we looked at for full eligibility and screened out again some records and included 22 records in our study. So let me mention some of the findings organized by those research questions. First of all, on the definitions, models, and systems for whistleblowing, almost all the sources had relevant information. This slide shows the definitions and the purpose given by 3 of the global organizations that were included in the study. Sources also discussed how to define who is able to blow the whistle or who is allowed to within the system, and that usually includes current and former employees. But in the health sector, there are non-employees who nonetheless might be witness to corruption, and that includes patients, their families, and volunteers, and also suppliers. Some sources defined retaliation very clearly, the types that would be that were not allowed and would be protected against. They described those available protections, how the system would manage confidentiality. If a person did give their name, how would the system maintain confidentiality? And how would they investigate and remediate reports of retaliation? What other kinds of supports did the system provide for whistleblowers, including counseling and sometimes financial support if they were retaliated against or they lost their job? They defined channels and modalities for reporting as well, who to report to and when. In the second question, the types and frequency of reports, surprisingly, we didn't find that many summary reports from organizations about how their whistleblowing systems worked. Only a quarter of the sources mentioned that topic. The three multilateral organizations did say that whistleblowing reports have been increasing over time. This may be related to the pandemic. The Global Fund to Fight AIDS, TB, and Malaria, which allocates about $4 billion a year to different countries and organizations. They credited increased whistleblowing reports to a communication campaign that they initiated and resource materials that they made available to grant recipients. The Gavi, which is the Global Vaccine Alliance, spends about $290 million a year, but they managed $4 billion in emergency aid during the COVID pandemic. And they reported that they received 67 reports in 2021 compared to only about 3 per year between 2013 and 2020. 16 of the reports in 2021 were found to have merit, and most were related to complaints about vaccine equity, distribution patterns of vaccines that were not related to the announced distribution or the standards that the company had set out or the organization had set out. Based on this information, the organization made a number of system design changes, but also the increased supply of vaccines in 2022 eased the pressure for rent seeking. So I think they had less corruption as well. These data are from the World Health Organization. They provided a report on concerns that have been reported through their integrity hotline in 2020. That was 11 months of data. They had 276 reports, of which only 22 or 8% were related to suspected fraud, corruption, or bribery. Most of the reports, about 58%, were related to concerns about safety during the COVID-19 pandemic and maybe omissions of actions that they were complaining about. No information was available from WHO on whether the investigations were completed and what were the outcomes. And in question 3, we looked at factors that affected whistleblowing. About a third of the sources mentioned this, though we found no specific empirical studies. These are mainly people talking about what they think might be facilitating factors or based on information from other sectors. Financial rewards, which people have mentioned already, assurance of confidentiality and protection from retaliation was very important. And they also mentioned that emphasizing one's duty to report could be a facilitating factor. This was mentioned at the beginning of our conference. Having multiple channels for reporting was also seen as important: face-to-face, web-based, telephone, as a way of being gender sensitive to encourage everyone, men and women, to be reporting. For question 4 on country or cultural context, we didn't find many sources that eliminated issues of cultural differences that affect whistleblowing system operation or effectiveness. However, some sources that mentioned India talked about how in a context where corruption is endemic and when a country is in this state, whistleblowing is harder because people fear retaliation more. The norms supporting corruption are strong and legal protections are weak. And this is where that idea of organizational culture and being very clear in leadership is critical. A similar situation was mentioned in the Middle East, North Africa, or MENA region. In India, one study showed that internal channels seem to be preferred over external channels in private companies. But the choice of a channel to report internally versus externally is also related to fear of retaliation. It might be related also to company size, and it's influenced by gender. People who had greater fear of retaliation tended to try and report externally. And the study found that women experience more retaliation, and that they tend to prefer external channels to blow the whistle. The study also noted that in private companies in India, people prefer to report, if they are reporting internally, they want to report to an ombuds rather than over the telephone or using web-based internal channels. I mean, I think people use all of these, but it's talking about trends and preferences. In China and possibly other countries with more collectivist cultures, whistleblowers may be perceived as traitors out to disrespect or sabotage relationships, not willing to fulfill their social obligations. This again signals that the organizational culture and leadership communication are very important. And our last research question related to impacts and consequences, we wanted to see how people talked about the results of the whistleblowing. Really, this was a lot of discussion of types of retaliation. We've mentioned this already, from social shunning up to and including death. There was little evidence of how whistleblowing or retaliation against whistleblowers led to any discipline, arrests, prosecution, or system level changes based on the information received. What we did see was two examples, one from Global Fund in Malawi, that the addition of a whistleblowing system did increase arrests and prosecutions, and in Morocco that a whistleblowing system where a patient could report that they had been asked to pay an informal payment led to the arrest and imprisonment of the provider. But I think we really want two kinds of results from a whistleblowing system. We want the individual corruption to be detected and punished, but we also want to make system changes, as we mentioned before, link this to risk management and strengthen the environment so there are less risks. In conclusion, a few takeaways. The design and the impact of the system really depend on organizational and contextual factors, as well as the motivational factors for the individual. So leadership style, organizational culture and values, design features such as having multiple modes of reporting, training, and a gender sensitive design to the system are important, as well as the things that motivate the individual. Secondly, there's not a lot of research available to guide these kinds of decisions by company officials or policymakers, particularly in the health sector. A focus of research in the future should be to analyze data from functioning whistleblowing systems to understand the frequency of reporting, the efficacy of certain pathways of reporting, and the timing, to document the impact of the reporting on the company, on individuals, and on rates of detected corruption. And individual companies should also try to document the perceptions, beliefs, and attitudes of staff relating to their intention to blow the whistle if they do see something, and their reporting preferences. And those could change over time. So if someone surveyed it at one period and implemented changes, they could detect any possible results. And finally, as everyone has mentioned already, whistleblowing protection is essential. Companies need to provide what protections and supports that they can, and to lobby government for legal changes that may be needed to further protect whistleblowers. And innovation should be encouraged to share the costs that it may take to support whistleblowing and to share the lessons learned. Thank you so much. And I had some selective references which will share this with people.
Thank you, Taryn. Thank you very much for an excellent survey report with facts and figures. Actually, these survey reports will help the respective governments and the entities and the corporates to have a robust whistleblower mechanism. These surveys are actually needed. And I really liked at the end when you said that impact analysis of these whistleblower mechanism is to be done. That's actually required. But at the end, like others, you also said that legal protection is needed. Now, till the time that protection is there, I don't think there can be a good beginning, an effective beginning of this whistleblower mechanism. I think we need to start from this protection and then we should come to the implementation of the whistleblower mechanism. Till the time protection is there, the whistleblower may remain on papers only. This is what my personal take is. Thank you so much. Now I invite Ms. Rajul Bohra, who being a lawyer, a partner with JSA, and has chosen a very fantastic topic of judicial accountability and standards. I would love to hear her. Welcome, Rajul. Rajul, please unmute yourself.
Sure. Hi, everyone. I'm actually very pleased to be a part of this eminent panel. Thanks, Mr. Madan, for the introduction and welcome you all. This topic is something that was kind of given to me by Santosh, not something that we've actually discussed in the last 2.5 hours, because this is judiciary that we are talking about. But I was thinking that sometimes we can draw parallels, and while I'll talk about judiciary and the whistleblowing in judiciary in the country, it is also very important to see where we can draw parallels there and how we have tried to do certain things, at least in the corporate sector, and to see if we can draw a parallel to our judiciary system and see where improvements are needed and what is it that we can do. I'll actually start with a very brief presentation that I have, where I will just take you through some things for like 5-7 minutes, just so that everybody understands what is it that we are talking about when it comes to whistleblowing in judiciary, and then talk about the issues that are there and what is it that we can actually at least discuss and see what can work in the judicial framework that we have. I mean, obviously, we are all people who are, here we can't really influence what can happen within the judiciary, but we can obviously give our suggestions to whatever limited effect that we are there. So I'll just share my presentation. Okay, is it visible?
Yes, it is.
Yes, it's not in presentation mode though. Do you have a presentation mode?
Yes.
Okay.
Perfect. Yes, perfectly fine now.
Right. So the first important topic actually comes about is what is accountability and versus transparency. Now, accountability and transparency, when we talk about judiciary is obviously immune. Our constitution of the country has given a lot of immunity to judiciary. But at the same time, since they are accountable to the country, to the people who they are giving justice to, there has to be an element of transparency. So while we can say that people are immune, but if we make them immune to an extent that we are not able to see what is it that is happening, then the important aspect of accountability, which is transparency, gets hampered. And that is a parallel that we can actually draw even in corporates, where you see that the board of directors, which comprises of senior people, the senior management sometimes, and sometimes also directors, are the ones who have to effectively then work with the audit committees, who have to work with the internal committees. They have to work on their own rigid mechanism. And sometimes when those people are part of misconducts and issues, it actually kind of becomes difficult. And that is the reason we had SEBI regulators, SFIO as an organization, which is the Serious Fraud Investigation Organization that has been incorporated under the Companies Act. All of these authorities have come in to give that neutral, the third sort of person within the corporate world to come in and actually see what is it that has happened. So investigation, as we say, has been given to such authorities. And therefore, the need in our judiciary to really have that element of transparency and how it can really be implemented. There have been incidents such as arbitrary misallocation of benches. We all know about the unprecedented press conference that was held by 4 senior judges of the country recently, where they spoke about how the system in India with respect to appointment of judges is not correct. And there are influences which are there, which is kind of affecting the merit-based system of appointment of judges. There have been death of senior justices who was handling the most controversial case of Sohrabuddin. There have been medical scams which have involved High Court judges. And then obviously the ex-Chief Justice of India was facing corruption charges in a land allocation case in Odisha. There's a brief history of where this actually kind of started. 2001 Law Commission of India, where these legislations were required. A bill was asked to be prepared. Nothing happened there. In 2004, the Supreme Court directed the central government to put some administrative machinery together. So something, there could be a law on that. I'm actually trying to go from the whistleblowing legislation and flowing into the judiciary. So that is the reason just talking about these events. In 2004, India signed the UN Convention Against Corruption and ratified it in 2011. Again, the Administrative Reform Commission report recommended we need a law on whistleblowers. 2011, the law Whistleblower Protection Bill was finally proposed. It got enacted in 2014, but to everyone's disappointment, it never was made effective. And the rules, in fact, was also, they were never finalized, which means that in India, there is currently no single law which actually governs all the whistleblowers. So when we talk about whether we should give them protection, whether we should give them anonymity, what is it, what sort of standards do we want to put in on how whistleblowing should happen, there is actually no single bill. While SEBI is trying to monitor listed companies to a certain extent, but there is again no single law which governs public and private sector whistleblowing in India. Like I said, Whistleblower Protection Act that it came in, while it was trying to cover all the public servants, but it was not. But it specifically said that public servants will not include judges of Supreme Court or High Court. So again, Whistleblower Protection Act, even when it came in, was not something that was covering judiciary in any case. For judiciary, there is a Judiciary Inquiry Act, which kind of says that how an investigation can be done. But there you have to have minimum number of Lok Sabha, Raj Sabha members agreeable on that, even to introduce that proposal in the parliament, if you have to impeach a judge. So the kind of standards that are mentioned under this Judges Inquiry Act 1968 are so high that we've actually not even seen one single impeachment until now in India when it comes to this act. So again, very ineffective. The second one that we can talk about is the 99 Constitutional Amendment Act, through which the National Judicial Commission Act was introduced. It was to replace the most controversial system of appointment of judges that is there in India. However, there were a lot of principles that were trying to come about in this act, but it was unfortunately, this act was struck down by the Supreme Court, saying that it hampers the independence of judiciary. So that also never saw the light of the day. Then the Judicial Standards Accountability Bill came out in 2010. It obviously was saying that there should be one body who can receive complaints, can do investigations. But again, this bill lapsed with the dissolution of the 15th Lok Sabha. So therefore, no progress achieved. There have been some judicial pronouncements where they have said that Chief Justice of India should be under the definition of public authority in the light of information. Can ask for their disclosure of assets, whatever information that has to be that can be asked under RTI. So the Supreme Court did say that CJI should be included in the definition. Also, in Justice Veerasamy case, it was held that under the Prevention of Corruption Act, when it comes to whether judges should be included under the definition of Public Servant Act, it was said that yes, judges should be included. So our judiciary in various judicial cases have been saying that yes, they should be included under various laws, but we've actually not seen any such implementation happen. Very interesting, in fact, just the last slide, where there's a question raised in the Lok Sabha that what is the status of corruption in judiciary? And finally, the minister answered this this year. In fact, it's very recent. And it said that Supreme Court in India in 1997 had adopted two resolutions, one on the restatement of values of judicial life, and second on in-house procedure for taking suitable remedial action against judges who do not follow these principles. Now, as per the in-house system that they have, the CJI can receive complaints against any misconduct of the judges of Supreme Court and Chief Justices of High Court. And the Chief Justice of High Court can receive any complaints against the judges of the High Court. But what is so interesting is that nobody actually gets to know what is the in-house procedure, how is it really done, who investigates, and what is the final decision that comes about. So while there is an in-house procedure that has been disclosed, but we are not aware of any decision, at least in public domain, on what has been done. So, I mean, as you all know, there is a CPGram portal that is there online, which was introduced by the Modi government a few years back. And there you could actually put in complaints against public servants, officers. It actually there, apparently what the minister disclosed is that in the last 5 years, that is from 2017 until 2021, 1631 complaints were received by this portal on the functioning of the judiciary, including judicial corruption cases. They were forwarded to the CJI and the Chief Justice of High Courts, and they've been dealt with as per the in-house mechanism procedure. Now, again, we don't know what was the procedure, what was the outcome of it, because they were just dealt with. So I mean, this is where I'll just stop sharing the screen. So this is where we are in terms of where the system is currently. And the unfortunate part is that while it is being spoken about that transparency and accountability can both be maintained together, we actually have not seen anything in action. There is no transparency, and that is why if you see the whole journey of companies law as well, whether it comes to SEBI guidelines of clause 49 of the listing agreement and the new regulations of LODR which are in place, if you really see the history of it, transparency should not just be there, it should be seen, right? So it's the same as justice should be seen to have been given and not just given. And that is why there is a need for a regulator to come in, even if it is for judiciary. We need to have an independent organization come in, which can really see these issues, because if judiciary is infected, I mean, we can't expect the other organs, whether it is legislature or executive, and then after that comes out to the entire corporate industry that we are talking about. So if our most apex organization is infected, it is very difficult to convince people to follow all these principles that we are talking about. And therefore, whistleblowing here becomes very important, whistleblowing protection, as well as the fact that at least in the beginning, for a few years, I mean, we have to see whether if we give someone the protection of being anonymous, what sort of results are we seeing? And we see that if people are anonymous and complaints are made, what is the investigation? What are the facts that come about? I mean, we can try this as a pilot project, at least for the next 5 years, and see. Because India, unfortunately, whistleblowing is very recent. While in the last 10, 15 years, we are talking about this concept and we are saying, but we still don't have a law on whistleblowing. So I would just like to end by saying that every arm of the country, whether executive, legislature, judiciary, or the corporate industry, they all have to show that transparency is there and not just there on papers. So that's how I would like to end my session.
Thank you, Rajul. Thank you so much for being vocal and being frank. I think speaking on this topic, the topic which you have chosen is also an act of a whistleblower.
Absolutely.
And I tell you, the answers to all your questions which you have raised, I'm just reminded of a recent interview of Mr. Ranjan Gogoi with one of the TV channels. He was asked a question about this corruption in judiciary. And you know what was his reply? His reply was that corruption is as old as society. Judges are also human beings, so they are also part of the society.
Oh, gosh.
He didn't say whether there is corruption in the judiciary or not, but what it says is as old as society, and judges are also human beings, they are also part of the society. Only a couple of days ago, I was reading about this some serious objection being raised on this appointment of uncle judges,
Yes.
particularly in Punjab and Haryana High Court. This issue has been raised many times, but there is no stoppage to this. Everybody is expecting the others to take some action, but nobody is taking any action. And on Facebook also, I see Mr. Markande Karzu. He writes so much about against the system in India, but I fail to understand why don't they speak when they are part of the system. When they're out of the system, they speak against the system. When they are part of the system, they don't speak against the system. Actually, the whole test lies that they should have spoken at that point of time if they actually wanted some serious changes. Thank you so much. I really liked your presentation.
Rate of job loss is everywhere, sir, at all level.
Yes.
Thank you so much.
Thank you. Now I invite Mr. H. Vincent McKnight, who has been there in this webinar since beginning, and he has been waiting for his turn. Sir, now your turn has come, and I've been told you're going to speak on effective whistleblower policies versus actions. So what is there on paper and what is actually being practiced? You're going to speak on that. Thank you so much. Welcome.
All right. Thank you very much for having me. I really appreciate the opportunity to speak to everyone here. And I commend you for embarking on this journey. I've been representing whistleblowers since 1995 in external claims before the Department of Justice, eventually before the Security Exchange Commission, the Commodities Futures Trading Commission, and also for the Consumer Protection Financial Board. And just to give you a little background about me, the first case I ever had in 1995, I ended up in the DC Circuit in front of Judge John Roberts, who is now the Chief Justice of the Supreme Court in the United States. And the other member of the panel was Merrick Garland, who is now the Attorney General of the United States of America. And Justice Roberts disagreed with me, and Merrick Garland agreed with me and wrote a scathing dissent. But I actually lost my first case, and that launched my career as a whistleblower attorney. And that's how I started things off in 1995. And so what I thought might be helpful to this group is to actually give you a few views that I have as a practitioner, because I've been doing this for so long, and what I'm actually seeing on the ground out here in terms of fraud. You know, and so a couple of the areas that I think have an international scope are the, you know, Foreign Corrupt Practices Act is a law that's in effect in the United States of America, where if there's a publicly traded corporation that's engaged in bribery or undue influence in a foreign country like India or China or any of the other countries, then that is against the Foreign Corrupt Practices Act in the United States of America. And so getting to your point about the pressure that's brought to bear on whistleblowers, I've had 3 or 4 Chinese whistleblowers come forward with information about bribery that's taken place in China by American corporations. And I've had at least 2 you know, Indian citizens come to me with the same complaint. And they were perfectly valid complaints. They described you know, money and other influence passing between corporations and government officials. And at the end of the day, these people declined to proceed because they were worried about not just what would happen to them and their reputations. They were actually concerned about what would happen to their families. And so at the end of the day, for concerns of safety, they backed out. And I think that's important for everybody to understand in terms of this whole discussion that you're having about the anonymous anonymity associated with whistleblowers and how important it is. What, in my experience, at least in the United States of America, they go after whistleblowers, just to be blunt about it. And the company tends to narrow the whistleblowers down to a group of possibly 3 or 4. The first thing they do in the United States of America and the corporate side of things is they try to figure out who the whistleblower is. And then they narrow it down to 3 or 4, because what they're really trying to do is build a defense. And meaning build a defense. How can we reduce and limit the harm that might be caused by this particular whistleblower complaint? There are financial issues at stake. There's also reputational harm. There are many things that might impact them, and they're concerned about the bottom line. And perhaps this is more of an American factor where capitalism and the dollar is king than it is in India, but I'm just sharing with you, what happens here. Another issue that has international complications, at least in the United States, is that the country of origin of a product often impacts fees and taxes of goods coming into the United States of America. So there are different duties and fees associated with the importation of goods. And one of the things I've seen, we have at least 2 or 3 cases like it right now, where they misrepresent the origin of a good in order to sidestep certain fees and duties coming into the United States. And we have a law here where there could be what's called a reverse false claim, and we can actually go after, a company for misrepresenting something like that in order to avoid a legal obligation. So that's something that has international implications. But the topic that I really want to talk to you about today is, it's important because it seems to me from listening to you today that India is at the beginning of its whistleblower journey. All right. That's what it sounds like to me. And so what I want you to think about from the very beginning is how fraud has changed and where fraud is today. Okay, and it's really, to me, this is what keeps me awake at night. And whistleblowers are absolutely essential to finding, discovering, and stopping fraud in our modern technological society. And the reason why that is because in our new environment, right? In our new environment, the new face of fraud is actually a line of computer code or an algorithm or a software program that is actually designed to identify a fraudulent opportunity and take advantage of it and then execute it in a nanosecond. We live in a world of payment platforms and a world where all money and things of value are transmitted in cyberspace through a digital connection. And so if you're a bad guy, and there are lots of them out there, if you're a bad guy, then you have to influence the way this digital communication is occurring to divert money and resources for your advantage. And so you have to begin to think of a digital universe, because that is where fraud is happening. And it's really it really is amazing, some of the schemes that I'm seeing right now. I'm going to give you a hypothetical. I think it'll drive it home to you, right? Let's suppose you're a customer buying a green widget on an auction site, and you set a reserve price of, say, $120. And so the second bidder has bid $80, right? So you should perhaps win the bid at 81, but you don't know what the second bid is. You just know your reserve price is $120, okay? Software programs and algorithms can identify the space between your reserve price and the space of the second bid and say, there's room here for us to maneuver. And then the next thing you know, you receive an email saying that you've won this green widget at $97, right? You don't think anything of it because it came under your reserve price. But the truth of the matter is that you were cheated the difference between $81 and the $97. And I give you that example because most payment platforms now are based on something called dynamic pricing. And dynamic pricing is a multifactorial pricing process so that there are several different factors that will determine what the ultimate price is. And unfortunately, the people who own the payment platform or run the payment platform, you know, just if you're an advertiser buying ad space with Google or Facebook or you're buying products somewhere, then you don't see all the factors that go into the final price that you're receiving. And you're getting a price and you're paying that price. You're trusting the payment platform to be fair. And what I'm trying to tell you is the payment platform is not always fair. And the sophistication of the artificial intelligence that is being used now to achieve some of these ends is absolutely amazing. It's not just cheating the individual. It goes deeper than that, because in the New York Stock Exchange, for example, Wall Street will set stock goals for every company. Okay, so let's say the Wall Street expects your stocks to be valued at $50 a share this quarter, and they expect that's your profits to be X or Y or Z. Well, these algorithms will allow you, right, to adjust your profits and losses in order to hit a certain sweet spot to actually manipulate your share prices. That's how sophisticated the algorithms are that are in place. That's where fraud lives today. Fraud is an algorithm. And so many of these tools that we look at that have made our lives better have actually made our lives more tenuous and treacherous. And so it's very, very interesting as I've been dealing with cases involving this particular issue of technology and fraud and how technology is used to execute fraud. I think many of us still in our minds live in a brick and mortar world where you go into a store, you pick up a loaf of bread, and they charge you a price and you pay that price. Well, many of the things that we buy, many of the services that we buy, many of the items that we buy, we no longer buy them at the store, we buy them online. And any payment platform, any computer invoicing platform has the ability to manipulate the information and the factors in order to cheat you. And so what I'm suggesting to you that you need to be aware of is when you're looking for a bad guy, right? When you're looking for somebody who might be doing something wrong, we always focus on hackers and third parties and people outside the company who may do something. And perhaps you need sometimes to look inside the company in the IT room and look at what are the programs, what's the software in place, what are the financial levers that affect the pricing structure and the invoicing. Because right now, that's where fraud is happening. Fraud is happening in code and in AI. And that's where the rubber hits the road. And it has no geopolitical boundaries, right? 50 Facebook and these platforms exist all around the world. You know, Google's all around the world. Ads are being purchased on all these different platforms. There are many different platforms in which you can buy and purchase goods and services, right? And so there are millions of opportunities for fraud to occur. And what I've discovered is that it's, at least in the United States, there's actually sort of a, a small group of computer engineers who truly understand, if you will, the pricing, these pricing algorithms and how they work. And so these people are in high demand. They go from company to company to company to company, right, while they're doing this. And there's a guy in a suit like I'm wearing my tie today who says, how can we increase our profits? Because there is there's pressure on the company to maximize profits. And most of your corporate executives have bonus structures that include shares. And so share price is important to them. And so if they can pump up the share price by manipulating a lever, it's actually in their best interest to do so. And so, but I think that we're all too trusting sometimes, and we don't think this is actually happening. And I'm here to tell you that it is happening. So at the beginning of your whistleblower program, consider technology and what is the best way to address technology and fraud. Because I'd say since the year 2000, this has become a growing problem, and it's global. It's an absolute amazing thing. Let me tell you something. I thought that I was amazed at this. You've all heard of the dark web, and you've heard that term, right? Well, it was about about 4 months ago. The United States Department of Justice, working with Interpol, shut down one of the primary dark web servers. And I thought that would be front page news because this is what I do. I'm always looking for stuff like this. But it wasn't. It was on the back of the front section of the paper somewhere. But, you know, you hear me talk about the dark web. And on the dark web, they actually sell malware and programs to bad guys so that they can infect your company and steal and create backdoors and ways in and things like that. I've seen on the dark web where they teach courses. The bad guys take courses to learn how to do these things. So as you think about fraud, think about technology, because that's where we are right now at this point in time. And the pandemic, in my view, put everything on steroids, if you will. We all started relying on the internet more to buy and sell things. And so one of the trend lines in the United States has been absolutely fascinating is that the street crime and regular crime has been on a steady decline for years, right? But fraud has been going up. I mean, the FBI suggests that white collar crime in the United States is worth somewhere between 500 million and $1 trillion annually. And yet, the Department of Justice, under the False Claims Act law, last year recovered maybe $5.6 billion, and the SEC issued about maybe $6 billion in fines, right? So we're leaving a lot of money on the table, and the bad guys are winning right now. And so I'm telling you, you have to go into this understanding that the bad guys are winning. And so how do we really get after that? And that's the question. And I don't have, you know, all the answers for you, but I do have, you know, years and years experience of watching how fraud happens, how it develops, and where the new frontier of fraud is. And this is the new frontier of fraud. So I commend you for developing these programs to address these issues, but think about where we are today as you do it from the very beginning. Because in the United States, I think we're just starting to catch up with some of this, even though we've been doing anti-fraud stuff for a long time, and we're still behind. So I'm encouraging you to think about this from the very, very beginning. How are you going to address these issues? And one more thing, the tech guys, the guys who write the code, most of them are really honest. It's true. They don't think about the fact that they might be stealing. If you ask them, can the program do this? They sit down and start typing away going, yeah, sure, the program can do blah, 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 blah. But they're not thinking about societal impacts. It's the guy in the suit from the business suite who comes down and says, can you do this? And the good thing about technology is it leaves a trail. You can tell when the program has been amended. You can tell who changed the program, and you can ask that person, who told you to do that? And so you can actually track it down. So it's a double-edged sword. On the one hand, it puts fraud on steroids, like I said before. On the other hand, if you go to the program and go to the technology, there's a trail there, breadcrumbs for who did it and how it got that way. And I'm just asking you to think about that while you're doing it. And that's all I want to say to you today.
Thank you. Thank you so much. I think so. The wonderful case studies being shared with by you, and Santosh, I'll request you that whenever you're going to host the next program, maybe it should be a larger one, and we should give more time to him. I think this is, and he will come forward with many other case studies, and we need to learn a lot from him. Thank you so much.
We have planned out, sir, a physical event. We seek to invite him in person as well from US. India would love to welcome.
That would be great. I'd love to come see you, but it's really
we'll be more than happy to receive you and welcome you.
Right. I live in the world of fraud. This is all I do. And my son practices with me and is co-chair of the department. And so we live in fraud. So while I'm here, I'm getting emails from the OCC and from other government officials talking about fraud. And I'm trying to set up a meeting next week for the DOJ to interview some of my clients about fraud going on at a big tech company. So this is where I live. It's all I do. And it's the way I feel about it is, and you all have said this, is if we can recapture this stolen money, there's plenty of money for schools. There's plenty of money to feed people. There's plenty of money to build new roads. There's plenty of money for healthcare. They're stealing more money than we could ever need to take care of all of the needs of society. So if you plug that hole, think about what good you can do for society. And that's how fraud affects all of us around the whole world. And so it's kind of a passion of mine, and I guess you can tell, right? But anyway, it's a concern of mine. So and so I'm really, really, really happy that you all are working on this very, very serious subject. And thank you for having me.
Madan sir, may I request you for one before we move to invite Savitri ma'am? I have a question connected to this particular topic which he has touched upon, and he has spent his life almost in this particular sector, and he mentioned about the technological aspect. So actually the idea that we wanted to learn from him, is there any experience or example wherein a digital voice of the whistleblowers has been ever created in the world, or if US has some sort of that solution to the world to give, wherein the problem lies with the whistleblowers. They know what to complain, they know where to complain, but they can't dare to complain, and the reasons are known to everybody. Can there be a possible solution wherein the digital voice, a platform can be created for the whistleblowers where they submit anonymously or with specific their identity, and then this problem can be taken up at the level of investigation or the resolution or something sort of that? Or even in case we are learning a lot about the blockchain technology everywhere, but why this type of technology can't be used for such a solution to give to the world or to the country in particular?
I think that in the United States and under most of the programs, say the programs at the Security Exchange Commission, at the Commodities Future Trading Commission, and they all have a mechanism for the whistleblower to remain anonymous. In fact, if you're represented by a lawyer, you can leave the whistleblower's name off of the complaint and just tell the agency what happened. And then the agency will contact a lawyer, contact me, and then we start setting up a meeting. I've even had meetings with agencies where they call my client Mr. Jones the whole time, even though that's not his name. And so they take great steps to try to protect the identity of the whistleblower. One of the fascinating things about this is that, like I said, the company is always trying to figure out who the whistleblower is so they can figure out what the harm is. You know, if they can figure out it's you, they can figure out by reverse engineering what you probably know and where the danger is. And they usually will work it down to about 3 or 4 people. And let me tell you what the SEC does, because it's kind of interesting. When you go to the SEC and you tell them that the fraud is here, right? They start an investigation out here and they act like they accidentally stumble on the target. And that's one of the ways that they use to try to protect the whistleblower. So they start out here and they kind of start asking questions and they take their time and then they reach the target in the middle. And by the time they reach the target in the middle, there are lots of people who may have been providing information, and they do that to try to protect the information of the whistleblower. In fact, if you look at the website, when they announce whistleblower awards, lots of times you don't even see the name. They don't even release the name even then. And so we do have an award system here, a financial incentive. That's important because a lot of these big companies pay huge bonuses to people. And so, you know, I was talking to a guy once about a whistleblower problem, and I asked him, well, who else knows about this? And he says, well, the vice president knows, but he got $100 million bonus last year, so he's not going to say anything about it. So this is what goes on in Silicon Valley, you know, where there's money flowing. So I talk too much, so I'm sorry, but you know, that's I think financial rewards are important because you have to counteract the money that they're giving, the company's paying, because you have a financial incentive to keep your mouth shut, right? If they're going to give you a bonus at the end of the year. So.
Thank you, Mr. Vince. You addressed my question. Indeed, I am grateful to have you this conference today. And I have personally learned a lot from you and the other speakers from Ms. Taryn as well. As you mentioned that you speak a lot, but everything is so meaningful, which is, of course, better than silence, which in case of whistleblowers, it remains otherwise at all different levels. So this is far more better, and I'm grateful. Thank you. Back to Madan sir, to you. Please carry on with other speakers.
Santosh, you know, becoming a whistleblower is also a job of a smart person. But I tell you, you said that you received the question, and after Vincent replied, you said, thanks for responding to my question. So it wasn't anybody's question, it was your question, it was an anonymous question, you know. Withheld your identity and asked the question.
Thank you.
Okay. Now I invite the last, what should I say in her honor? The encyclopedia to me. Last speaker, Ms. Savitri Parekh, Company Secretary and Compliance Officer of Reliance Industries Limited. Savitri, I'm putting some of the posers before you, rather the bullet point before you, which in my view you may cover in your presentation. Otherwise, you are at liberty to cover whatever you so desire. Maybe you may begin with the disclosures in the LODR with respect to whistleblower mechanism. Secondly, you may cover that I think there is some award scheme by SEBI, award to be given to whistleblowers. Is that actually working and functioning? Third, is there any penal provision for the malicious complaints or malicious, somebody is blowing the whistle maliciously or falsely? maybe to settle some personal score. Further, what sort of actually protection mechanism have been provided by the corporates or the audit committee to the whistleblower? And all this you may discuss if you have any case study also available with you, because you have into the corporate sector for last so many decades. Maybe some case study will help us. I know I'm putting so much before you, but the time is very short.
Sure. Thank you very much, Madan. It's indeed a pleasure to be addressing the gathering on a very important topic as whistleblower policy and vigil mechanism, as it is called in India. Talking of the legal framework in India, we have the Companies Act of 2013, listing obligations and disclosure requirements regulations of 2015, as well as CARO 2020. As you can well see, it's 13 onwards. In fact, the Companies Act 2013, most of the provisions came into effect from 1st of April 2014. Although the law per se was implemented from end of August 2013, most of the provisions came into effect only from 2014 April. So these are the three main provisions in which you would find provisions with respect to whistleblower policy and vigil mechanism. Let me start. While your question was on listing regulations, LODR as it is commonly referred to, let me start with Companies Act. In Companies Act under section 177(9), there is a requirement for the listed companies, every listed company, which would basically mean every equity listed company, and a company which has accepted deposits from the public, or a company which has borrowings from banks or financial institutions of an amount exceeding rupees 50 crores Indian rupees, which is about 500 million Indian rupees, is required to establish a vigil mechanism. And this is for the directors and employees to raise genuine concerns. The term genuine concerns is quite a broad term. So the employees and directors are entitled to raise genuine concerns under the vigil mechanism or whistleblower policy, as it would be called. Adequate safeguards are required to be provided to a whistleblower, and in fact, a whistleblower can even take the liberty of directly approaching the audit committee chair instead of filing a written complaint or doing the going through the skip level manager. A person can just directly approach the chair of the audit committee and voice his concerns or her concerns to the audit committee chair. Further, there's also a disclosure requirement, one on the website of the company, disclosing the whistleblower policy, as well as in the report of the board of directors. Details are required to be given. The whistleblower policy is also required to be mentioned on the website of the company, as well as in the director's report, board's report, as it is called. Now, actually, if you refer to the rules, it basically refers to the kind of companies that are required to establish vigil mechanism, and similar provisions you also would find under LODR, although LODR has slightly more detailed provisions. In fact, it starts with the principles governing disclosure and obligations of the companies, where under the head of rights of stakeholders, the reference has been made to whistleblower policy and vigil mechanism. There's a separate regulation dealing with vigil mechanism, which is actually a mirror of provisions of Companies Act. That is, any director or employee can voice genuine concerns and raise the issue with respect to any practice. Now, actually, it could be a practice which is not legal, or which is not in line, in sync with the principles of the entity concerned. So, any genuine concern can be raised under the whistleblower policy. There's also a requirement for website disclosures, whether it's an equity listed company or a debt listed company. The website is supposed to have a copy of the policy. The role of the audit committee has been very clearly brought out in LODR, where it says that the audit committee shall review functioning of the whistleblower mechanism. So therefore, the audit committee has been obligated with this responsibility of seeing as to whether the mechanism is functioning effectively or not. Also, in the annual report of the companies, as per Schedule 5 of LODR, details are required to be mentioned, which means the annual report should carry details of establishment of whistleblower policy or vigil mechanism, and also an affirmation is required to be given by the companies that no person has been denied access to the audit committee. Now, this is a very important provision. Now, in sync with this, if I were to move on to the requirements under CARO 2020, that is Companies Auditors Report Order 2020, which came into effect from the last financial year, that is financial year 21-22 onwards, there is a specific requirement for the auditors to state that they have gone through the complaints with respect to whistleblower policy of the company. So if any complaint is received by the company, the auditors are supposed to be checking, reviewing, and giving a specific affirmation in their report of such whistleblower complaints. So this is a very, very important provision which shows that the lawmakers have very clearly provided a framework for raising genuine concerns as well as for protecting the interests of the whistleblowers. Moving on to your next question on award which has been provided in the regulation itself under the prohibition of insider trading regulations, there is a provision providing for monetary awards to persons to informers, as I would call them, who come up with wrongdoings, especially in the context of the securities market. Something which came into effect recently, and therefore there are no precedents as of now which are in public domain. Penal provision, the rules very clearly provide that if any director or employee has been repeatedly making malicious complaints, which under the whistleblower policy, which is not genuine, then action can be taken against such persons, because it's actually of no benefit whatsoever, and it does not really fall under the head of whistleblower complaint if it is just malicious without any merit whatsoever. Lastly, going on to your last question on protection of whistleblowers, it's clearly provided in the statute, and also the companies are required to afford protection to the whistleblowers. If at all there is any complaint which is raised, the whistleblower should not be victimized, and protection from victimization has been clearly provided in the statute itself. Of course, in India, we do have one or two cases where the whistleblowers did not get the protection as the way it's come out in public domain. But in case of private sector, there is a very clear policy, and most of them do ensure that they are protected and the complaint is anonymized to the extent possible, although the identity is known to the audit committee. Over to you, Madan. I've just tried to be a little brief because I'm conscious of the time, and I must mention that it was great listening to the the speakers before me. Taryn, Rajul, and Vincent were absolutely amazing. I would just like to add one more point in the context of whistleblower complaints. Adding on to what Vincent mentioned, there was a heavy emphasis on fraud, and the CARO report of the auditors actually is linked to the paragraph on fraud. So, which basically means that they look at whistleblower complaints as something which is going to give you on a smell test a color of fraud and a smell of fraud, which is exactly the reason this has been included in the report of the auditors. Over to you, Madan.
What you said that regarding protection, what sort of protection is being provided actually?
So it's protection from victimization. So just because a person has complained, one does not. So the first thing is ensuring that the identity is not publicly shared, and nor is it known to persons who are going to be investigated. If there's an allegation against a person, the company will not divulge the identity of the complainant to the person who's being investigated against, so as to ensure that there is no victimization. And protection would, if at all there is a fear of something more, then even physical protection will have to be given. But most companies do respect and ensure that it is anonymized. While the identity is known to the audit committee, as I mentioned, the identity is not disclosed to any other person. And even the complainant is requested to keep it confidential until the investigation is completed.
I just received a query on my WhatsApp with respect to this audit committee only, that how many audit committee chairpersons are personally managing the whistleblower line. And what he said, that he's also from one of the MNCs, I tell you. He says, in fact, many have handed over to senior management in the company, like company secretary or legal, etc. Which means that although it appears to be safe from outside, the protection of sensitive whistleblowers can be a big issue. Is it so?
I don't really agree with this, because see, it's not that the telephone line needs to be handled by the chairperson of the audit committee. It may be handled by a third party too. But what is important is the person who's handling the phone call. Let's say, for example, if there is something which is very sensitive, the complainant will never divulge all the details to the person who's attending the hotline. He or she would ask for a private audience with the audit committee chairperson, which will definitely be granted. So it's not about attending to phone calls. It's, you may possibly get around 100 phone calls, and not all of them may be genuine concerns. Very often during appraisal time, there may be complaints relating to HR related issues. There may also be a few complaints relating to behavioral issues. I'm not for a moment saying that they're not important, but they have to be distinguished from the other complaints which smell of fraud or are something which are not very ethical. So it's not about attending to phone calls, but it is about being able to grant an audience, which must be granted if any of the complainants seek an private audience with the audit committee chair.
Savitri, you said that whistleblower can be either an employee or a director of a company.
That's
so
right.
in case of a director, why should he become a whistleblower? If he is a part of the board, should he not discuss at the board meeting itself?
So the law provides for the director also to complain. It may be, while it can certainly be raised at a board meeting or at an audit committee meeting by the person concerned, all that the law tries to do is to provide an opportunity. So he's not kept out, and if he sees that there is something which he's not comfortable with, he certainly can take it up, and which is what the enabling provision in the law is providing for.
Under section 143(12), the auditors, all three auditors are required to report the fraud.
That's
if they
right.
report any fraud, should they be treated as whistleblowers? Or it is a statutory duty to report?
So actually a fraud could be because of a failure of an internal control or lack of an internal control, or it may be because of a fraudulent act done by one of the persons in the organization. So if it is a failure of an internal control which has been taken advantage of, let's say for example, if the closing stock is not regularly checked, and therefore you do find a huge difference, and it is by one of the distributors, and the employee concerned has left the distributor's employment, that would be definitely a case of a fraud. But at the same time, it is not played by one of the persons in the organization. But this is one where the internal control is either weak or is not there at all. This has to be distinguished from one where there are unethical practices or something which has been intentionally done with an intent to defraud by the organization.
Now, in case of a company, suppose that there is a complaint filed by a whistleblower, and ultimately on investigation, the complaint is found to be true. Now, whosoever has done this fraud or committed this fraud, do you recall any action has been taken under section 447 of the Companies Act 2013?
So under 447, I don't think there have been any decisions till date. and because 447, you will have to wait for the prosecution and the order in prosecution by the special court to be passed. I don't think there have been any as yet in India.
Last but not the last question from my side.
Although, of course, NAFRA has taken up few cases and they are yet to be, orders under 447 are yet to be passed, although they would be alleging 447 too.
Okay, the last question from my side. Have you ever observed that any complaint has been filed by a whistleblower to settle some personal score, or it may be a petty HR issue also by an employee of the company?
Well, that's a fact of life. It does happen where sometimes people do file few emotional complaints, but at the same time, the ethics committee or the whistleblowing committee of the company would consider these, and every complaint that is filed would be considered on merits, and then you would treat it as one which falls within the scope of the whistleblower complaint and one which does not fall. If it's one which is with respect to an HR related issue, purely an HR related issue, it would not be treated as one which needs to be considered by the audit committee.
Thank you so much. Whether any of the panelists would like to answer on any of the questions I just raised? Any of the panelists would like to have share his or her views?
I have a question, sir, in case in between, if somebody to...
Yes, please. This is your question?
No, this is not my question. The question comes from participants only.
Okay.
So the question is that we have experienced the scenario wherein the political people, they have, filed the case against one on another, maybe between the state to another state or between the state government to central government. So the case happens in ways wherein the counter attack is done under the defamation act, section 499 of the IPC. So, and then settlement takes place, as you mentioned right before a few minutes, and there is one way. So do you think that in case a whistleblower complaint is implied, where in such case the defamation section 499 IPC should not be applied until and unless the investigation is completed or the report is in place? So what is your view? Should there be any amendment in the whistleblower policy, or because the interface is there linked each to one to another?
Do you want me to address that?
Please, ma'am.
Okay. So, well, 499 of the Indian Penal Code, which deals with defamation, is when something is published, it could be in print media or it could be in any other medium, and which is not true. And truth is certainly a defense in proceedings against 499 of IPC. So while on the one hand, the detailed investigation with respect to a defamation case under the Criminal Procedure Code would definitely take much longer, and it would require a lot of evidence to be produced before the court. Typically, what happens is that the media would claim privilege because you're not required to reveal the source from where you've got the information. So therefore, if you're claiming that it is true and you have reported the facts as you have heard them, then it's going to be one person's word against the other. But most often, what happens is, along with just facts being reported as something which has been heard or seen or said, typically what happens is views are also given. When you give views, you are exposing yourself to action under 499 of the Indian Penal Code. So long as you have not given views, it's okay, because media will be entitled to privilege, and whoever is saying so will also be entitled to privilege. Now, if it's the print media or the electronic media, people are generally aware of it. But if it's a blog site or any of the social media sites, one is not very clear about all these provisions of law, and therefore you're exposing yourself to risk of action by any other person. In any event, if you're doing it as an individual, without having possession of full facts. Please don't write something because you're going to expose yourself and you're going to have personal liability too. And this is only under the Criminal Procedure Code and IPC, but you also could run into problems with a heavy suit being filed against you claiming money, if it's a money suit. So that's with respect to defamation. And coming back to your second part of the question as to whether any action is, whether some representation could be made with respect to this, the simple one that I would say is that there are very few countries around the world where defamation is still a criminal wrong. So that's something which could be reviewed.
Excellent.
Thank
I
you.
think
Thank
you
you
were
very much, ma'am.
very well. Savitri was very well prepared for the question also. Wonderful.
I don't work in the media house.
But I tell you, for non-compliance, even for compliances of the provisions, sometimes these defamation suits are filed. I remember the two of the top-notch directors of some Tata Group companies. They filed a defamation case when the Tata Sons proposed resolutions for the removal from Tata Group listed companies. And then when the requisition was sent by Tata Sons, certainly certain allegations were there against those directors. And no doubt, ultimately they were removed, but they filed defamation suit. But ultimately that got settled with the intervention of the Honorable Apex Court.
Cool, sir. So may I request Ashok Halia sir, he is there, and GP Madan sir to please conclude, and then.
No, from my side, it's concluded. I'm so thankful to all my panelists, and thank you everybody, and thanks to you and the ASSOCHAM. Thank you.
And I'm really thankful to GP Madan sir, Madam Savitri Parekh ji, Dr. Tarrant, Ms. Rajul Bohra, and Mr. H. Vincent for your time through this day, your contribution. We will come out with the proceedings of what the discussion has taken place today. We will try to circulate across, and if you may like to further add on those views, which can really make some impactful submission to the regulators, government, we would like to take this up to the relevant authorities in India with all your guidance, Madan sir. And may I request Ashok Halia sir, are you still there? Because I can see you are there, but would request if you can please add on, and then we say final thanks to all. I think that, yeah.
Thank you, Santosh ji. You know, having heard Ms. Savitri Parekh and also Mr. Madan and our two distinguished international experts, I think I have anything to add. And the way Savitri ji has elucidated responded to the question, that was excellent. And that gives the clarity of thoughts in her mind and clarity of thoughts in her expression. Of knowledge that these gentlemen have. So indeed a great pleasure and a great learning for me as well. So, you know, this is how one gets, one learns, and through the interaction, through the listening to the experts. So, but you have rightly said that the suggestions of this would be documented, and then would be sent to the participants and also at least to the faculty, and if they want to add on anything. And as I said in my inaugural address or maybe later session, that if you can demarcate these suggestions into different categories, what is relevant for the policy, what is relevant for the corporates, what is relevant for the regulators, the government, and also the whistleblowers themselves, that would be of a great help. And I would believe that would be a pioneering effort on the part of ASSOCHAM. So with that, thank you very much, Santosh. You know, I
Thank
think
you,
we are all.
Ashok Halia sir, for your kind support throughout this conference and before that, mentoring the conference as well. And
No, it was in my self-interest, because I was venturing on a topic for which I did not know anything. And you know, becoming a chairman is an easier thing, that you may not know anything, but then still you can pretend that as if you know everything.
No, you always justify and give the justice to the panel session whenever your role is there, sir. Thank you so much for being this, and we thanks to all these support partners in the Renew Power, SpiceJet, PCIL, then Smart Bharat Group, Exchange Partner, BSC Investor Protection Fund, and Reliance Industries Limited for supporting this initiative, which of course was in a way of conference first to our references. And we think that more is required to do, and we would continue seeking your support, guidance from the experts in India, outside India, from the world, because for the world to say India is a continent, for the world to say India is a continent to do business. But when we look at the whistleblower, we don't know where he is living, in which part of the country. But when his fear comes out, whether to really submit the complaint or make the complaint or not, then it's very small place. India is a small place to live and to safeguard the interest of the whistleblowers. So I think that the information which has been shared across by the international speakers, national speakers over here, would be of immense use, which should be in the interest of the whistleblowers in future, and for the overall, enhancing the level of the good governance in the country as a by and large. And thanks for all the support from different stakeholders, speakers, all the way. Thanks to my team from Corporate Affairs, Legal Affairs Department, IT team, and we look forward to your continued support. If you have further feedback, suggestions, please write on my email ID santosh.parasar@veritasocm.com. I will be back to you personally with a request to further guide us that how we can make a big change in terms of how the whistleblowers are dealt with, or how the whistleblower policy is being taken care in country at different levels. Thank you so much for your support and time throughout. Thank you so much.
Thank you very much.
Thanks to all the speakers and attendees here.
Thank you. Thank you, everybody. Bye.
Thank you.
Thank
Bye.
you.